My lord, under compelling circumstances, may I beg to mention one matter, my lord. Item number 1570 of the monthly combined list of June. My lord, the difficulty is my passport has been impounded and till date it has not been released. If I cannot join my service abroad, my lord, I will get sanctions for absolutely no fault of mine. Moreover,
Hey.
my lord,
Please come next week.
My lord, for release, my lord, on a CSC matter, item number 877.
What were you doing for the entire month? It didn't come to your notice that this is a CESC matter?
My lord.
This is the last week.
That was running in the list of honor justice, code number 551, my lord.
How did it come here?
Thereafter, my lord, this matter was listed when your lordship was determination.
This bench has lost determination to take up electricity matters long back. What is the item number?
877.
877 released. Are you the advocate on record?
Yes.
May I have your lordship leave to mention a matter for withdrawal, your lordship?
Withdrawal means?
Withdrawal of the writ petition, your lordship. It was filed last week, your lordship, but we found that some facts has not been stated, your lordship.
All right.
That's why I'm mentioning this matter for withdrawal. I am the advocate on record. Let it appear tomorrow, your lordship.
Yes, to be mentioned.
Your lordship may be permitted to mention a matter for arbitration.
No, sorry.
I am praying your lordship's leave to file a writ petition, my lord. Here, one of the petitioner has crossed the prescribed age limit as prescribed under
Please, in the filing section. Call the list, please.
Not a very urgent writ petition, my lord. This is against the serious fraud investigating agency. My lord, an investigation commenced in January. I never missed a date to participate in the investigation. Now, my lord, when I have to travel in July to, my lord, Japan for my son's education and for business, my lord, I'm not being I'm not being allowed to board the flight. My lord, on 7th or 10th of July, I have a flight to Japan. My lord, if lordship will kindly take up this matter and grant us leave at least to travel, because I have never defaulted in participating in the investigation process. I know, my lord, that I am not entitled to a lookout notice.
Who is investigating?
It's the SFIO, my lord, the serious fraud. But may it appear any day subject to your lordship's convenience tomorrow or day after tomorrow, my lord.
Very difficult. Extremely difficult. You have to wait till the next week. Yes.
Listed next week, any day.
Yes, next.
May it have some precedence in your lordship's.
Next week, please mention. I'll accommodate. Next week.
I'll come back next week.
But may I permit to mention one contempt?
But on the day of mentioning,
yes.
Not the day of your choice.
Yes.
The first working Monday of the month is the mentioning day. Please come.
Yes, I'll come on Monday.
And in case Monday is a holiday, then the very first working day.
Very yes.
But may I permit to...
Your lordship, I'm appearing for the Union of India, your lordship. Certain fraudulent accounts were opened in the post office, your lordships. And
what you want?
Your lordship, my matter may be listed in...
Your matter? It's not your matter.
Union of India, your lordship.
Is Union of India the petitioner?
Yes, your lordship. They are challenging the state redressal forum had passed an order in... district had passed an order in favor of my client, your lordship. Thereafter, the state...
Where is the matter?
It's WPA 128.
Where is it? Is it listed?
No, your lordship.
It's not listed. You want inclusion. First Monday of the month.
But may I permit to mention one contempt application, my lord? Contempt application, some precedence, my lord. My lord was pleased to direct the distribution license.
There in the list?
It was appearing some precedence, my lord.
No, is it there in the list?
It was appearing in Thursday.
Thursday list? This Thursday also it will appear? Bring your other side. Yes, item number 1.
My lord, I am for the petitioner in this matter.
Yes.
My lord, your lordship will remember, my lord, the contempt arises.
Contemptor who is appearing?
The contempt arises out of
petition. I have not been.
My lord, because contempt is
against of your lordship.
All right. It was adjourned.
Because, my lord, the corporation, Kolkata Municipal Corporation said, my lord, the advocate on record's father has passed away. Yes. My lord, your lordship has almost indicated your lordship's mind that if the order is very clear, that it's the my lord, special executive engineer who has to, my lord, pass the reasoned order. The special officer building has my lord, presided over the entire proceeding and has passed an order. My lord, we have said that we have also, my lord, brought it to the notice of the special officer building that you are not the person concerned by your lordship's order. It was supposed to be the executive engineer.
One submission I made. My lord, your lordship was pleased to direct the executive to deal with the matter. My lord, from the order, executive dealt with the matter, processed the file, show cause notice, everything has been prepared by the executive, thereafter sent to the higher authorities, and higher authorities sent it to the special officer.
At what stage was it forwarded to the higher authority?
after show cause notice and after preparation of sketch plan.
Hearing was not conducted.
No, he was directed to deal with the matter.
Yes.
Deal with the matter. He was understood that to process the file as the appropriate procedure as applicable in the corporation. He has sent the file to the authority. Higher
The
authority.
executive engineer also has the jurisdiction to handle the unauthorized cases matter.
Circular of the municipal corporation, executive engineer has a limited jurisdiction regarding consideration of this particular demolition and change of use proceeding. That is up to 3-storied within 150 square meter. These type of stipulations are there. Beyond that, he cannot himself take a jurisdiction unless the honorable court directs.
Here the court.
Yes, kindly come
Probably
to page
directed.
180.
Deal with the proper matter.
What is the stage now?
Yes,
Stay order has been passed by the special officer. Now the matter is pending before the municipal MIC, and very next meeting the final decision will be taken with regard to the order of the special officer.
But I am
Whether it
saying
will be
that,
approved or not.
but I am saying that person could not have, and he does not have the power to regularize. But he has also gone ahead and regularized everything. But kindly see, we have written
See,
letters.
that
below.
order is an appealable one.
Yes.
Yes.
The order of regularization 401 has been invoked.
401, 416 both.
16 change of use was also there.
But my lord, we approached
are
this
also
honorable
there.
court, prior to the passing of the order. We filed this contempt before. My lord, kindly comes to page 180. 180, my lord, volume 2.
Why is the contempt application so voluminous?
My lord, we have annexed the writ petition, my lord. I have taken note, my lord. We will not do so. Next time. Page 180, my lord, second
Yeah.
paragraph. But deal with means, my lord, he should do everything. How can he, my lord, delegate in the teeth of the order?
He has not delegated. Delegated has been made by someone else.
It cannot be. Cannot be. Then he should have come and sought for a clarification. But why the special officer?
17th of April, it was already there.
But we have written letters to the person concerned that please do not take up the hearing. You are not the person concerned. Lord, kindly come to page 229, much before the passing of the order, and we have filed the contempt petition before this order has been passed. Even then, my lord, he has not stopped and he has proceeded. Why this hurry? Why this rush? Page 229, categorically asking the executive engineer to take it up.
Has this order been communicated to all parties?
Yes, my lord, they were there.
Right. It is mentioned over here that the covered parking spaces must be restored within a period of 30 days from the date of communication. Has this been done?
No, my lord.
No, my lord, I have said that it is for final approval went to the MIC desk, and MIC's next meeting.
What does this mean? You say the stand of the corporation. Do you have a copy of this order of the special officer?
Yes, madam.
Please come to page 2, part A.
Part A.
I am inclined to pass the following order. The covered parking space must be restored within a period of 30 days from the date of communication of this order.
Yes,
Order has been communicated.
yes, madam.
Now you say it has gone to the special, higher authority. What does this mean?
Confirmed there is a circular.
What does this mean? What is the use of communication of an order which is not required to be complied with? Does it make any sense?
I appreciate prior to MIC's approval, this should not have been communicated. I accept.
So this order simply doesn't have any force.
No, force, it can be extended, mother to kind. After municipal commissioner's order, a fresh notice can be given for compliance. After MIC's
An authority passes an order that you have to do X, Y, Z within 30 days of communication. I communicate this order. Now suppose, assuming this person acts in accordance with this order, and now this order goes up to the higher authority and the higher authority does not approve it.
Yes.
What will be the position of that person who has acted in accordance with this order? It is not necessary that this order will be confirmed.
No.
It can be remanded back for fresh hearing.
Partially confirmed.
Anything. Otherwise, you've mentioned you act, failing which action will be taken by the department. So there is a threat of taking action. And action is a coercive action. Change of use at covered car parking spaces will not be allowed. Ceremony use will not be allowed in the ground and the first floor without NOC. Now the use must not be continued.
Department may inform the licensee and take action.
A lot drastic things have been allowed.
Part B. As sprayed by such and such diagnostic, the change of use may be allowed on payment of fees applicable to be paid within 30 days from the date of communication, failing which action will be taken.
How can this be done, my lord? I propose a question, my lord. Kindly come to
Similar.
Same thing.
No, not similar, my lord. Kindly, my lord, subject to correction, my lord. Kindly see, my lord, for the first page. My lord, kindly see first page, my lord, 4. Paragraph 4. The corresponding entry to this direction. Tenement area at first floor, southern side has been converted from residential to institutional, as in commercial, now occupied by NKG Diagnostic Center beyond sanctioned regulation plan. And he simply says, pay the, in part B, as paid for by NKG, change of use may be allowed. He has constructed beyond the sanction area and he's now allowing his change of user also. Doesn't even have the authority. That's why he's going up to MIC and all that.
SA is present here. I also told your
very unfortunate things are going on.
You should not have communicated prior to taking decision by the MIC.
Let the executive engineer.
This proceeding was the very first page I see.
Yes, Malad.
Car parking spaces converted into shop. Absolutely impermissible.
Yes.
Residential area converted into pathological lab.
Yes, my lord.
You cannot do without a permission.
He has given
Construction of RCC slab supported by RCC column along with such and such, all are in deviation violation of the sanction plan.
He has regularized everything by payment of fees.
What is the use of a sanction plan? If you permit someone unauthorized thing to be regularized?
But, at the present, I can say only one thing, that the person concerned who is aggrieved, they may prefer an appeal before the trial.
That is a different thing.
And Malad, one
different thing.
legal point I was that in a contempt application,
The court will not look into the validity of the order that has been passed.
this is my respectful submission.
No, this is the order of the Supreme Court and the court is also aware of it. Right? But the manner in which the authority has acted in accordance with the order appears to be absolutely contrary to the direction passed by the court. This is, you do not need a contempt jurisdiction to ascertain this. Anybody can see the first paragraph and the last conclusion that has been drawn.
Only one humble.
I am not hearing you, please.
Only one humble.
Sorry, please. I am not hearing you.
The point
Not a party.
I am not hearing you. There is an order placed before the contemptor before this court.
Authority.
Yes.
I was there, so was the other side. No one took this point that he
all over.
I have
over
my letter.
You can take steps.
Not participate, Milord, by raising that objection.
Yes, I have.
And when was this forwarded to the higher authority?
19th June. It has been
The order was passed on 16th of April. What was the reason for holding back the file for more than 2 months?
We filed the contempt, then, my lord.
Oh, my lord, after passing the order regarding payment of different fees, the calculation has to be made.
What remains?
Yes.
What further approval do you want?
With the calculation, it has to be sent to the MIC.
What else is required? Nothing is required. Show me the circular according to which the matter was referred to the higher authority.
At present, I can
Bring it. Please come. Had submission made on behalf of the petitioner and the contemners. Step. The order of the special officer within bracket building dated 16th April 2025
I'm taking your lordship.
is perused. Stop. It has been submitted that learned advocate for the contemptor submits that the file has been sent to the MIC on 19th of June 2025. Stop. Next. Learned advocate for the petitioners stress on the fact that the special officer building did not have the jurisdiction to pass any order in the matter, and the executive engineer is the competent authority to deal with the unauthorized construction in terms of the order passed by the court. Stop paragraph. Learned advocate representing the contemptor is directed to produce all relevant circulars.
Circular, my lord, order, kindly cease order, but kindly say order.
Acha, order. Order of whom?
Order of the municipal commissioner, he's stating.
Order of the municipal commissioner. Bring the act also on the next day.
My lord, I have
Because I do not have the
One
act.
thing, my lord, kindly consider one thing. Since MIC will be take decision soon, so my lord, kindly direct that the file should be processed by any authority. Should not be processed by any authority or by the MIC. Whoever may be. If they take a decision, then it will be very difficult, my lord.
Ki bollam?
Representing contemptors is directed to produce all relevant order
Of the municipal commissioner. Commissioner relating to the issue as to whether the executive engineer could have forwarded the matter to the special officer building for consideration despite order.
He has not forwarded, my lord.
Who has
to higher authorities, that is the DG building, from there it has been forwarded.
To the higher authority, likhun to ki bollam? Can forward the matter to the higher authority despite a specific order of the court directing the executive engineer to deal with the issue of unauthorized construction. Yes, as the contempt is pending consideration before the court, no further step shall be taken in respect of the subject file until further order. Stop. Release the matter for further consideration on next week.
11th.
11th.
Possible for you.
All right, 11th.
Mal.
I am grateful to your lordship, man.
Item 2. I am appearing for petitioner.
Yes.
Affidavit of service.
Right.
Second time I decided.
What is your submission?
Lord, after filing this writ petition, the respondent bank has issued a letter that has been recorded in the first order also.
All right.
This is the writ petition for issuance of a sale certificate in favor of legal heir and registration of the same. Originally, the sale certificate was issued in the name of one Lakshmi Narayan Saha. The said person was died bachelor. After that,
when?
In 2021.
And the matter pertains to the year 2013. Sale took place in 2013.
Yes, my lord. A sale certificate was issued in 2013. Pursuant to that, my lord, possession was handed over. Original document in respect of flat was also handed over. In 2018 and 2021, his mother and father was expired. 21, he was expired. Thereafter, brother and sister is the petitioner herein. They approached the bank.
For what? For what?
For issuance of sale certificate.
Why sale certificate has been issued? How many times will a sale certificate be issued?
Sale certificate issued in the name of legal heir and registration of the same.
Why?
And bank has suggested them to produce the legal heir certificate.
Where is the?
At page 17, my lord. Kindly come to page 17 of the my deed petition.
And this letter was communicated after filing of writ petition.
5th of May. This letter is dated 5th of May. You filed it on the 6th. Anyway, what is your prayer in the writ?
Prayer, my
Where is your approach before the authority?
is the 27th March 2025 at page
25, 24.
at page 24.
Please come. A legal representation from the end of the petitioner before the respondent bank requesting registration of the sale certificate in favor of the legal heirs of the auction purchaser is pending consideration. Stop. None represents the bank despite service. Affidavit of service is already on record. So, in the absence of the learned counsel for the bank, comma, it is not possible for the court to decide the issue conclusively. Stop. Paragraph. In view of the above, the instant writ petition is disposed of by directing the branch manager of the bank senior manager, respondent number 3, to take steps to consider and dispose of the representation made on behalf of the petitioner strictly in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties by passing a reasoned order to be communicated to the petitioner at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Writ petition disposed.
Obliged.
Communication of the senior manager of the bank dated 5th May 2025, addressed to the learned advocate of the petitioner, filed in court today, be written with the records. Yes.
Hearing for the private respondent number 2, my lord, Mr. Moinak Ghosh, he is coming.
All
Let
right.
him come. My lord,
Yes.
come.
But this is the matter, my lord, where the issue which was pending before your consideration, whether, my lord,
award
writ under 226 will be maintainable
against
an order styled as an award. Because, my lord, my first point here is that, my lord, award has to be an award within the meaning of the Arbitration and Conciliation Act. And, my lord, the Arbitration and Conciliation Act, being a special statute, prescribes a procedure for challenging an award also. First, procedure for making of an award, and if the award is made in accordance with the provisions of this act, then a challenge procedure is there.
All right.
So, my lord, if we are to avail an alternative remedy point, the alternative remedy must presuppose that the award is in terms of the act, and remedy under 34 is available to such an award. Here, my lord, is a case where my point is that there is a time period prescribed by the Arbitration Act within which an award has to be made. There is also a procedure under the Act. If the time period is over, then there is a period to come to court and apply for extension of time so that the mandate of the arbitrator revives. And he becomes an arbitrator vested with jurisdiction under the Act. Here, my lord, what happened, my lord? 2021, the pleading was complete as per the award. Thereafter, my lord, 2020, Lordship knows 15th of March 2020 due to the lockdown. The period was suspended under all. So, my lord, I say that even if we take that period which is suspended up to February 2022, period revives from 1st March 2022. So that 1 year period comes to an end on 1st March 2024. Now, my lord, here your lordship will find that the award is, so-called award is dated 12th of February 2024 and communicated in 2025 January. Well, if I do not take the date of communication, your lordship will take the date of signing, which is 12th of February 2024. There is no reflection in the award that any time was extended. So, my lord, my case is that this is not an award. This is an award order which is a nullity, which is not an award within the meaning of Arbitration and Conciliation Act 1996. Therefore, there is no alternative remedy under Section 34. Now, this is my first point, my lord. If your lordship recall, I had cited one Supreme Court judgment, which was, I think it is, yes. This is 2021.
19 SCC
Yes.
206?
Yes.
Yes.
I had specifically placed, my lord, your lordship will kindly see.
Paragraph 2 you've read out?
The facts. Kindly come
Facts.
to paragraph 18.
Yes, 18.
Yes. Just if I may place these two lines, my lord, order dated 6th August 2012 is a nullity and runs contrary not only to the provisions of MSME Act, but contrary to various mandatory provisions of the Arbitration and Conciliation Act 1996. So this is the point, my lord. The order dated such and such is patently illegal. There is no arbitral award in the eyes of law. It is true that under the scheme of the Arbitration and Conciliation Act 1996, an arbitral award can only be questioned by way of an application of 34 of the Act. At the same time, when an order is passed without recourse to arbitration in other disregard to the provisions of the Act, the 34 of the Act will not apply. We cannot reject this appeal only on the ground that the appellant has not availed the remedy under Section 34 of the Conciliation Act 1996.
Did any conciliation proceeding commence?
Yes. What happened here was, first there was a conciliation under this Act, then the matter was referred to arbitration under Section 18.3. And 18.3 prescribes that when it is referred from conciliation to arbitration, then the provisions of Arbitration Act will become applicable. So, my lord, when it is referred to arbitration by the council becomes the arbitrator under the Arbitration Act, my lord. But here I also point out, my lord, we had raised the point of jurisdiction of this council to act as arbitrator in an earlier writ petition. That writ petition, because at that stage, my lord, my writ petition was dismissed, saying it is a jurisdictional issue. Since a jurisdictional issue is raised and an arbitration is proceeding, you have a remedy to go before the arbitrator. That was the, my lord, observation, and my writ petition was dismissed. Thereafter, I preferred an appeal. By that time, this order has come. So the appellate court did not interfere. So, my lord,
please show me the order of the single judge in the earlier matter.
Yes, sir. Kindly come to, my lord. It starts at page 245. This third volume.
Yes.
Kindly see the first paragraph. The petitioners seek quashing of arbitration case registered by respondent number 1 against the petitioners. Petitioners seek setting aside of all proceedings initiated or being conducted by the Facilitation Council under arbitration case number. Petitioner number 1 is the buyer, respondent number 2 the supplier in transactions between the parties. Then, my lord, I'll show your lordship the relevant. Then maintainability point was raised in paragraph 3. Supplier raised a preliminary objection on maintainability. Objection rests on the ground that petitioners cannot seek a mandamus for quashing of arbitration proceedings pending before the council, since the petitioners have an alternative remedy under the Arbitration Act. Then your lordship will kindly see paragraph 5. which is the preliminary objection has been dealt with. Preliminary objection before respondent number 2 is required to be dealt with first. Petitioners have sought for issuance of writ in the nature of mandamus. Provisions of the Arbitration Act provide several routes of statutory redress to an aggrieved party. This would include Section 34, which gives recourse to a party against an arbitral award. 37(1) and 37(2) provides for appeal. Section 16 empowers the tribunal to rule on its own jurisdiction. Then paragraph 6, it has been held that therefore petitioners have multiple effective alternative statutory remedy under the 1996 Act. Prayer for quashing of the arbitration pending before the council is also contrary to 18.3. 18.1 deals with reference to micro and small scale facilitation council, makes the provision exclusive and applicable regardless of any other law for the time being in force. Section 18 starts with a non-obstante clause. 18.1 authorizes a party to a dispute with regard to any amount due in relation to the goods, services rendered by the supplier to make a reference. 18.2 empowers the council to conduct conciliation. 18.3, but all this is said. Then paragraph 7 says, provisions of MSME Act makes it clear facility has been conferred with exclusive powers to decide a dispute on the provisions of 96 Act after the failure of conciliation proceeding. Fact that conciliation failed would appear from council's letter, which records that conciliation process has been terminated as the parties could not arrive at a settlement. Letter also records council will proceed to initiate arbitration on 18.3 read with 18.4. This letter was addressed, but this is going on merits. Then, my lord, paragraph 9, ultimately, my lord, paragraph 10. They say that the alternative statutory remedy in the present case is not only sufficient and effective, but also multi-layered. But here I just want to say one thing. This was at a stage when proceedings were rightly being conducted under the Arbitration Act. At that stage, it was not an jurisdictional error. The proceedings were rightly initiated under the MSME Act. Conciliation failed, referred for arbitration. Proceeding was in progress under Arbitration Act. Therefore, alternative remedy in the sense of Section 16 was available to challenge the jurisdiction of the tribunal on whatever grounds. What is the position now? Now the position is, my lord, we have come across one order which is mentioned as an award. If it is not an order permitted under the provisions of the Arbitration Act, then 34 is not available to me.
So it is your contention that though it started off under the Arbitration and Conciliation Act, the same could not be concluded within the stipulated time period. It was passed long beyond. That is the reason it cannot be treated as an award. It's a nullity.
Yes, it is a nullity.
This is your
Yes, this is my
sum and substance.
So on that, my lord, I have cited one judgment of the Supreme Court, my lord.
This one.
Yes, 2021. Other point which I would also like to take is that with regards to the alternative remedy point, this is again my alternative argument. Because
34. Setting aside of the award.
Yes, if it is argued that it is an
award,
under the Act and there is an alternative remedy available.
Yes.
Then, my lord, my next point will be that alternative remedy principle, the writ courts still exercise jurisdiction despite existence of an alternative remedy if it can be shown that the alternative remedy is onerous and it's not efficacious. So the alternative remedy must not only be alternative but efficacious. Now, your lordship will kindly see section 18(1) of the MSME Act. Uh, 19(1) of the MSME Act. Kindly see section 19. Application for setting aside decree, award, or order. So the scheme of the act starts with this act, conciliation, referred to arbitration, then becomes Arbitration Act. Then again, your lordship will see section 19 comes into play. I have to revert back to this provision. No application for setting aside any decree, award, or other order made either by council itself or by any institution or center providing alternative dispute resolution service to which a reference is made by the council shall be entertained by any court unless the appellant, not being the supplier, has deposited with it 75% of the amount in terms of the decree, award, or the case may be the other order in the manner directed by such court. Now, if your lordship sees page 31, what is the extent of the liability of a honest adjudication? It says outstanding due amount is 50 lakhs 10,000. Buyer is liable to release the due amount of 50 lakh 10,000 along with interest of 3 crore 40 lakhs 4,000. So, my lord, it is not only interest is 6 times the principal, and I will have to deposit 75% of this amount. Of I could have, if it is an award meaning the meaning of section 34. Now, my lord, final argument which I say is that, my lord, it is not a remedy available under 34. Your lordship kindly consider the situation. Any order which is non-est, it is a nullity in the eyes of law. At the most, it can be said, I can file the jurisdiction of a civil court is not barred. I can challenge it by way of a civil suit. But I cannot come under 34. If your lordship has to look at the grounds of 34, 34 grounds are restricted only to the parameters which the statute has considered in the context of an award being passed. There is no ground where there is no mandate. There cannot be a ground because the mandate is not there, award is non-existent. This presupposes if I was not heard, if it is contrary to public policy of India, if it is patently illegal. So all these are grounds. If the arbitration agreement, I am not a party, disputes do not fall within the arbitration. These are grounds of 34. So I say that an award beyond mandate is not an award, and that is why the legislature consciously did not include such a ground within the meaning of 34. Kindly have a look at, my lord, once the grounds in 34. So my submission is 34 is not a remedy for this case.
Now, the submission that you are making that it's not an award, right? It's an order. Then your submission of non-filing a suit, what will your submission be as to why you did not file
Filing of a suit is not an alternative remedy under the statute. That is a general remedy available to all citizens of the country. Section 9 of the Civil Procedure Code says
no, it's all right. You say it's not an award.
It is not an award. But
so it's an order.
It is an order which
why
is,
under 226 and not the
because my lord, 226 I have acquired a legal right. It is a violation of a statutory right, where my civil rights are going to be affected as a result of this non-est order. Right under 226 is not taken away by reason of the section 9 of the CPC. 226.
No, that's all right. But then, anyway.
Here, my lord, it is an infraction of my legal and statutory right. This is why 226 lies, and it is not. There is no alternative remedy according to me. Section 34 is not an alternative remedy under the statute for this kind of a order. Now, my lord, lordship just has a glance at section 34. Why I say that 34 is not the remedy. Kindly see subsection 2. Arbitral award may be set aside by court only if party making the application establishes on the basis of record of the tribunal that one, party was under some incapacity, arbitration agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law for the timing in force, party making the application was not given notice of the appointment of arbitrator or of the arbitral proceedings, or was unable to present his case. Arbitral award deals with a dispute not contemplated by or not falling within terms of submission to arbitration, or it contains decision on matters beyond the scope of submission. 5, the composition of the tribunal or procedure was not in accordance with the agreement of the parties. Then B, subject matter of dispute is not capable of settlement by arbitration under the law for the time being in force. Then, my lord, kindly see explanation 1. For avoidance of any doubt, it is clarified that an award is in conflict with public policy if it affected by fraud or corruption, contravention with fundamental policy, conflict with basic notions of morality or justice. So what I say, the legislature was very conscious. Legislature was conscious that it had to be completed within this time. If it is not completed, 29A is incorporated by amendment. Then, my lord, it cannot be said that you still have 34 remedy if an award is passed beyond mandate. It is of no effect. According to my submission, it is of no effect. It is as good as a piece of paper. But when it has the capacity to be misutilized by the other party for securing an advantage which will affect my right, then I cannot sit back and say that it is as good as a piece of paper. I have to invoke my remedy under Article 226 to have it formally declared bad and as non-est. That is what I have done by this writ petition. And therefore, my other previous writ petitions will not stand in the way.
All right.
Now, my lord, I had cited Supreme Court. There is one division bench of Bombay High Court also on entertaining 226. Yes, this is a division bench of Bombay, my lord. 2021 SCC Online Bombay 3113. Kindly see paragraph 3, just the fact. 2. By filing the petition under Article 226 and 227, petitioner has sought for quashing of orders dated 8th May 2015 passed by respondent number 2, as well as order dated 5th September 2015 passed by the respondent. Then, para 3, by the order within bracket award dated 8th May 2015, MSME Council in application number such and such, filed by respondent number 1, directed the petitioner to pay principal amount of such and such together with interest as per section 16. Then, so this is the challenge to the order, my lord. Now the background facts are also similar, my lord. Paragraph 12, your lordship will see. Reference was made, reference was forwarded for conciliation under 18.2. Conciliation proceedings, petitioner raised the issue that claim of response barred by limitation. Conciliation proceeding failed, matter referred to arbitration. Para 13, after lapse of about 2 years, petitioner was informed about hearing. Though petitioner was represented, there was no representation on behalf of respondent number 1. Matter was adjourned. Petitioner took the stand that respondent number 2 had no jurisdiction. Application number such and such was not maintainable. Then, 14, respondent number 2 passed order award directing petitioner to pay the principal amount of such and such. So this award is under challenge. Now, my lord, your lordship will kindly come. My lord, paragraph 22 is the preliminary objection taken. Ultimately, my lord, kindly come to paragraph 77. From a careful analysis.
Yes.
Para 77. From a careful analysis of the above 2 judgments of the Supreme Court in Patel Engineering and Modern Industries, we find that the view of the Supreme Court is that any and every order made by an arbitral tribunal would not be open to challenge or being corrected by the High Court under Article 220 or 220. So ordinarily, an order or award passed by the Council under 93 Act is to be challenged under 34 or appealed against under Section 37. Then, my lord, paragraph 78. In Arun Kumar, Supreme Court discussed was the jurisdictional fact and held that a jurisdictional fact is a fact which must exist before a court, tribunal, or authority assumes jurisdiction over a particular matter. It was held as under. Then, my lord, paragraph 79. Supreme Court held that a jurisdictional fact is one on the existence or non-existence of which depends jurisdiction of a court, tribunal, or an authority. By erroneously assuming existence of a jurisdictional fact, no authority can confer upon itself jurisdiction which it otherwise doesn't possess. Thus, existence of jurisdictional fact is a sine qua non or the condition precedent for exercise of power by a court having limited jurisdiction. Then it was held as under. The existence of jurisdictional fact is thus sine qua non or condition precedent for exercise of power by a court of limited jurisdiction. Then, my lord, your lordship will kindly, jurisdictional fact has been discussed. Then, ultimately, if your lordship can kindly come to paragraph 86, referring to the facts of that case. On the basis of the above analysis and legal provision, we may now advert to the facts of the present case. As noted above, contracts were awarded by petitioner's predecessor in interest to respondent number 1 on 6 November 99. Principal amount as per statement of delayed payment were up to 31st August 2001. MSME Act came into force on such and such. Respondent number 1 received registration under section 8(1) of the Act on 14 February 2010. Reference was made by respondent number 1 to respondent number 2 under section 18 on 13 September, claiming principal not received for last 10 years and therefore claimed interest. There is no affirmation in affidavit of respondent number 1 or any document placed on record that it was registered as a supplier under 2F of the 93 Act or under 2N of the MSME Act. So, this was on the question that they were not supplier within the meaning of the Act. Discussing that, your lordship will kindly see 88. The above are jurisdictional facts which are absent before respondent number 2 could assume jurisdiction. In the absence of jurisdictional fact, respondent number 2 could not have proceeded under 18(3) and could not have passed the impugned order award dated such and such. As held by the Supreme Court in Arun Kumar, in the absence of any jurisdictional fact, respondent number 2 rendered itself quorum non judice. This is my case also. After 1 year, any order or award passed by an authority which is rendered quorum non judice is a nullity and can certainly be interfered with by the High Court under Article 226. Therefore, reverting back to our discussions made in para 37 of this judgment, from an analysis of the judgments of Supreme Court in such and such, position becomes very clear. While the High Court in exercise of its jurisdiction on Article 220 would not entertain any and every order passed by a tribunal, certainly the High Court would entertain an order or award passed by a statutory arbitral tribunal which is a nullity, or when the tribunal had rendered itself quorum non judice. So I say that I am coming within this part, that though initiation may have been proper in my case, I had a point of jurisdiction which I could have taken, but subsequently it has become quorum non judice.
Yes.
So, my lord, this is my point with regard to 226. My lord, I will also show, my lord, just for the record, that the earlier Supreme Court judgment which I had cited, this was considered in a subsequent judgment by a 3-judge bench. And there, the Honorable Supreme Court noticed some divergence of opinion with regard to the entertainability of 226. The bench, however, expressed its view that 226 is maintainable. It is not to be discarded outright. If it is a jurisdictional issue like this, it is definitely maintainable. But then it framed the questions and it has referred it also, my lord, to a larger bench, my lord. This is 25 Tamil Nadu.
Right now, we are at a very preliminary stage with regard to the maintainability of the writ petition.
This is only for the records. Otherwise, I say that, my lord, I stand on Jharkhand Urja. I just show your lordship 2-3 paragraph to just to show that the view and that it was referred. Kindly come to, my lord, paragraph 53 of the judgment.
Yes.
This is 2025 4 SCC, page 1. Issue which arises and needs consideration is whether there would be an absolute and complete bar to inherit writ jurisdiction under Article 26, even in exceptional and rare cases where fairness, equity, and justice may warrant the exercise of writ jurisdiction. Then, my lord, kindly see in paragraph 56, Harbans Indian Oil Corporation and Whirlpool in 57, all has been quoted. Then finally, your lordship will get that it is not a complete bar. There, your lordship will see that paragraph 56 following paragraph 55 and 56, where there is the violation of principle of natural justice, whether an order is wholly without jurisdiction, where the virus of an noticeably as a statute perform the statutory role functions within the four corners of the law. Then 56 and 57, it says, in an appropriate case, in spite of availability of alternative writ, courts can exercise at least in 3 contingencies referred to above. Then paragraph 57, para 27.3 is the exception. And in paragraph 58, it has been said, it would be true to say that existence of statute does not affect jurisdiction of the High Court to issue a writ. Nevertheless, writ jurisdiction being discretionary, writ court generally insists the parties adhere to statute. This reinforces, however, in exceptional cases, writ jurisdiction can exercise power to access the court. Then 59, your lordship will see, Constitutional bench of 5 judges in 1954 had observed that principle of High Court should not issue a prerogative writ when an alternative may not apply. Kindly noted, when remedy under the statute is onerous and burdensome in character.
Very good.
Then, my lord, the questions have been framed. So, my lord, I rely on, my lord, till it is decided, Jharkhand Urja, my lord, holds the field.
Yes. I will hear you on the next day. It's already 11:46. Only on the issue of maintainability.
Your Lordship, I appear on behalf of the Council. Your Lordship, after Mr. Bose concludes his argument, I will also make few submissions.
You also raised the issue of maintainability. Right. Please come.
No, I have raised it by way of an application.
Yes.
He supports the issue raised by us.
Yes.
Thing is the same. You pay an application,
Yes,
he
yes,
without an application.
Issue
thing
is the same.
Heard the senior counsel appearing for the petitioner in support of the writ petition. Start paragraph. The issue of maintainability, which has been raised by the respondents, will be taken up for consideration on the urgent date. Date bolun. Friday. Friday will be difficult. Both Brihaspati. 9th of July. I'm keeping it next week.
Very well. 9th July.
Gratefully, Your Lordship.
বইটা ফেরত দিয়ে দেবেন আর ডাকবেন না
My lord picks up the appellate side matters, my lord. Item number 5, if it could taken up day after tomorrow, my lord.
Let's see tomorrow what happens. Nobody knows day after.
Item number 4. And the other side is there, my lord. My lord, Advocate General is appearing in this matter, incentive matter. But I had also indicated I have some personal difficulty on second. On second.
Second.
That's why my lord are pleased to keep this on 30th, but due to my lord could not
Let
be.
us see
Reading of press tomorrow.
Advocate General is also not there. My junior would be there.
Tomorrow also he'll not be there?
That is at no.
My lord, may I seek for indulgence, my lord? Since this matter has been heard by your lordship substantially, if this matter may be marked as part heard, my lord.
No.
My lord, if
Lord,
it can taken up, my lord, on third, my lord, if can be.
Very well. Please make this prayer tomorrow. I'll consider.
My lord, may it please your lordship, my lord. First application. Thank you, my lord. I am led by Mr. Rai.
In one, my lord, I am for the respondents.
Okay.
But one, my
Yes.
one has become infra to us, I think, because no, my lord, may I just point out if I can start, my lord. My lord, one is a restoration application of, my lord, a writ petition which had been filed challenging a show cause notice issued by my learned friend's client. Now, my lord, that matter, my lord, there was an order that we should go before the appellate authority and they will pass an order, but that will be subject to that writ petition, my lord. Now, my lord, obviously, my lord, it
Also, there is
downgradation.
downgradation.
That also includes, my lord, that there will be no downgradation of my client, my lord, in the listing, or rather vendorship, my lord, if I say so. Now, my lord, it is our fault, the advocates, my lord, they missed the matter, my lord, and on the last day, my lord, on Thursday, last Thursday, my lord, this restoration application was moved. That's on the 26th of June. On that day, my lord was pleased to at least put it upon us as to what we are going to pay, to whom are we going to pay as a, well, as a condition for the restoration. We have done that, my lord. Immediately we had done that, and we have also got the compliance. It was fixed for compliance today, my lord. Now what has happened, my lord, knowing that it has been, my lord, dismissed, they have sought to downgrade me on that same day, with the letter being 1 day prior, on 25th. Now, therefore, my lord, I had to take out the second writ petition. The point is, my lord, everything, even if they had passed that order, my lord, that would have been subject to the first writ petition. But because it is not there, my lord, we have been constrained to file both, my lord, a new writ petition challenging the second one, and my lord, the restoration. Now, my lord, on that day, if it stood restored, my lord, your lordship, with humility, I say, my lord, restorations generally, my lord, when it is, my lord, restored, my lord, the interim orders are also restored, unless, my lord, there was something mentioned in the first order, my lord. I'm sure, my lord, I don't have to show judgments for that. Now, my lord, if that is, my lord, restored, my lord, then, my lord, this letter which they have issued should be subject to the hearing in the writ petition, which is there, my lord. Then, my lord, in that case, my lord, I can beseech your lordship that let them also file, my lord, some kind, they must have a reply to my new writ petition. Let them also file, and both the writ petitions be taken up together. Till they are disposed of, my lord, they should not give effect to this, my lord, downgradation, which I say, my lord, wouldn't have been there unless it was.
All right. Show me the impugned order in the first writ petition.
Yes, yes, madam. First
what exactly was impugned in the first one?
First writ petition. Copy
the second writ application, till now we have no instruction to appear. I think only yesterday it was copy was given.
And in this one, they filed an opposition, my lord. May I?
Opposition has also been filed.
In the,
yes, in the first
all right. Show me the order.
Yes, my lord.
এই অর্ডারটা আমাদের restoration
অর্ডারটা যেটা চ্যালেঞ্জ করেছে সেটা দেখতে চাইছি মানে কাইন্ডলি bears with me. I have not been briefed in the first read, but I just assist your lordship. And kindly give me page 151, my lord.
151.
151. And orderটা এবার দে।
restoration application
is the same order there annexed in the second one also, so it will be easy
no,
for
the
you.
Order is different, my lord. I'll point out, my lord. May I've shown this, my lord. Now, my lord, sees your lordship's order, my lord.
The restoration application
restoration নয় first order যেটা যাচ্ছে পাস করেছে মানে it's in the second writ petition. If your lordship kindly take the second writ petition, please number বলুন.
All right. The first writ petition order impugned was dated 2nd January 25, and the same order mentions with regard to an appeal that could have been preferred by the person aggrieved within 60 days.
Yes.
Right. No appeal preferred.
No, my lord. Your lordship had directed us to go to appeal.
All right. You went
and
there.
The lordship had also directed, my lord. I'm showing that order. Order to copy to them.
Yes, I'll have order over here.
Page 187, my lord. Your lordship's order.
I'll have order in the file. You went there.
I went. Your lordship said that they will pass an order, but it will be subject to the
result of the writ petition. At that stage, the writ petition stood dismissed.
This is for default.
Right. And
On that,
thereafter, a fresh order has been communicated.
the appellate order has been passed.
Communicated to you.
Yes.
Before the dismissal, the order.
And according to my learned friends, client, my lord, whatever I have understood, the order they are saying is prior to the dismissal. But I don't have anything on record to show that. But my lord, it was dismissed for default, my lord. My only submission is, my lord, even if that order was dismissed for, was passed, my lord, in the event the dismissal was not there, my lord, it would have been subject to a writ petition.
Yes, yes.
And they shouldn't have given effect to it. Now, my lord, they are now giving effect to it because there is no order at this moment, my lord. That's why I filed, my lord, for abundant caution, my lord, filed this second writ petition.
And my lord, the appellate authority was pleased to pass an order initially. Subsequently, it was found that without giving them any opportunity of hearing, it was passed. Your lordship was pleased to set aside that order and give a direction for fresh consideration.
Where is the order of the appellate authority?
Yes.
First order is page 227.
My lord, page 227, my lord, the second writ petition.
It gives a rise to
Do you have a copy?
appellate authority copy, soft copy is there, my lord.
You must be having a copy of the recalling application.
Yes, that was given.
In the recalling application, see the copy of the appellate authority's order is annexed.
Yes,
So
yes.
check up. Check up.
Order ta kothay? My lord, 227, if your lordship kindly sees, is the first appellate order of the first order passed by the appellate authority.
Yes.
This was also set aside, my lord.
Right.
That is at page 252, my lord. Because no hearing was given.
Now what is under challenge?
My lord, now 350, 350, my lord.
50, all right.
Here, my lord, very interesting, my lord. There, my lord, I am present, but my lord, the RDSO is not present.
350.
351. 351.
My lord, that would have been my first challenge, my lord, because if the appellate authority cannot hold the brief for the RDSO, my lord, RDSO was not present. My lord, kindly comes to, my lord, page 351. Your lordship will find the persons present.
Yes.
Respondent.
In the box?
Yes, my lord. I do not find any respondent, my lord. There's the RDSO.
CEO, GM Sales, Legal Representative.
And my lord will kindly see, then your lordship will kindly see submissions advanced by the appellant. Your lordship finds 2.
Yes.
Then my lord straight comes down to 3, my lord. Observations of the appellate authority. They do not even know what the other side shouldn't know. What the other side's case is, my lord. They are not present. And straight away, my lord,
An order is passed.
an order is passed. Now, my lord, I can show that the order also does not, my lord, take into consideration several of my submissions, my lord. I can show that.
To scissors by way of the judgment also.
Relation.
25 জুন চিঠিটা।
And my lord will kindly see 359. It will explain everything. How they are giving effect to this order, my lord.
$359. 25th of June.
Yes.
Downgrading.
This is also under challenge before your lordship, my lord. Kindly sees by, my lord, may I just read, my lord? My lord, second paragraph. However, in compliance with the High Court's order date, Honorable High Court's order date of 11 February, Covis and were advised by letter that in meantime, response shall permit the petitioners to participate in tender process as approved by vendors. As approved vendors, the fate of the petitioner's application shall be subject to the result of the writ petition. And accordingly, a remark was added in the vendor directory against the name of the firm. Now, Honorable High Court has given verdict in case number dated 17 June 2020. Also, legal opinion was sought, but verdict is dismissed for default. May I just point it out? And also, legal opinion was sought from the counsel in the case, and accordingly, remark has been removed. And now, firm is to be considered list of RDS of vendors for development orders. This is downgrading, my lord. So, my lord, the reason For giving effect is, my lord, that the dismissal, my lord.
You have not been shut out. You have been downgraded from one position to a lower grade.
Much lower grade, my lord.
All right. And that is because, according to the authority, you cannot reach the level, the QAP.
No.
Quality assurance
And
plan.
may I just point out, my lord, the initial, now the history, my lord. The initial show cause was that under QAP 2, I was supposed to source these breaks from Kovis, Slovenia. Now, this is a pure company's law subject will crop up. Now, Kovis, Slovenia is an integrated constituent of this company and a joint venture partner in this petitioner number 1. So it is in the petitioner. Now they say that why did you not get it from Slovenia? Not Kovis, Slovenia. You should get it from Slovenia. Now, Slovenia is not the point. The point is Kovis, Slovenia. And there is a transfer of technology by Kovis, Slovenia. They are same here. They are building it and doing it here. And pursuant to what, may I just point out? The Made in India policy which has been set forth by the government. On one hand, they say you do it Made in India. And I've also received a show cause for that also. I'll just point that out there. There, the railway department is saying the other way. Otherwise, why have you not done 90% in India? And here they're saying, why have you not sourced it from Slovenia? And the most important thing is, there is not a single complaint with regard to this quality of the disc. They've been approved and they are being used.
In Rajdhani, Shatabdi,
and all the major trains are using this. So, it's a catch-22 situation, One side made in India, one side is, why did you not get it from Slovenia? The question will be, what is the meaning of sourcing? And if I have to source it, where I am supposed to source it from the person who is a part of me, then can I not say that that is the person who is building it? Because I am what percent shareholder? 50% shareholder. Kovis, Slovenia is 50% shareholder in the petitioner number 1. On record, they are well aware that there is transfer of technology. Everything has been given. In such circumstances, the only harmonious reading can be, that I've sourced it from Kovis, Slovenia. I'm getting it jumbled, sorry, Kovis, Slovenia, sourced, outsourced, and not from Slovenia. It's not written there. Sourced it from Slovenia, but made in India. Then I can only fulfill both. Or else I cannot. And if there was a complaint, I would have understood. That is why I'm before your lordship, and that is why I believe, I was there. I wasn't there on the first occasion. Your lordship had therefore, passed on that will subject to this writ petition, and that I will be allowed to participate as in my same capacity.
My lord, in this second writ application, till now no one is representing.
I understand, my lord. He's saying that yes,
this is a purely technical issue. Kindly, if your lordship is to pass an interim order, kindly pass the interim order after hearing the response. Kindly fix a short date.
My lord, may I just say this? Sorry, my lord.
Restoration will be allowed.
The restoration is allowed, my lord. That order stands restored, my lord.
Yes, I'll restore the interim order also. That is all right. But thing is, you are required to take instruction.
Yes. Purely
And,
technical issue. Without taking instruction from the engineers, what is the actual difficulty?
I do not intend to hold this back. I want to finish it off.
My lord.
Right?
My lord.
Because this is a policy decision whether you'll permit them. Its safety issues are concerned.
Yes.
So a lot of issues.
Yes.
And
without taking instruction, no one is.
Continuation of an interim order will
And in
not
fact,
be proper.
I do not know whether I shall remain engaged in the second matter or someone.
That is
else
something
will
different.
Come, yes. In the second matter, kindly do not pass any interim order.
All right.
No, my lord, I was only beseeching, my lord. My lord,
If the interim order in the earlier one is restored,
then
you
the
are
effect is that, my lord. They should at least act in terms of that first order, my lord.
Please come. Show me the receipt of the Bar Association.
Yes, my lord, the compliance. Evidence of compliance? My lord, this is the
Sorry, my lord,
evidence of compliance.
Acha.
দেখে নিচ্ছিস তো?
দেখে নিয়ে তো দিয়েছে 10 লর্ডশিপ annexure A I have deposited 10,000
আচ্ছা এটা হচ্ছে 32, 34, 25 can 2. Application for recalling the order. Dated 17th June 2025. Stop. I have heard the submission made on behalf. Now, এটা কেটে দিন, আপনি লিখুন, an affidavit has been filed by the petitioner enclosing the receipt issued by the Bar Association High Court Calcutta showing payment of rupees 10,000 rupees. Stop. The interim order. Now, the order dated 7th June 2025 stands recalled. Stop. The writ petition is restored to its original file and number along with the interim order that was passed by the court on
February 2025. Extension কবে হয়েছে বলো? Last extension.
ওরা নিজেরাই বলেছে আপনার কাছে আমরা তো আগের দিন যে বলেছি ওখানে ডিসমিস ফর ডিফল্ট করলো
11th of February.
কারণ
Stop paragraph.
interim order restored technically invalid.
Acha, can disposed.
Yeah, even on the TikTok.
WPA 14430 of 2025 এ একটা order লিখুন. The order passed by the appellate authority on 6th June 2025.
26.
রেকর্ড করে দিচ্ছি
Rejecting the appeal of the petitioner is under challenge in the instant writ petition. Stop.
To the communication, madam, kindly, madam. Of 25th,
By communication dated 25th June 2025. The petitioner's firm has been downgraded and is presently presently enlisted in the list of RDSO vendors for development orders for manufacture and supply of standardized brake disc for LHB coaches. Stop. Next. Prior to the downgrading, the petitioner was enlisted in the list of approved vendors. Stop. As the court has to adjudicate with regard to the correctness of the impugned order passed by the appellate authority. Accordingly, the learned advocate representing the respondents is directed to come ready with proper instruction. Stop. Release the matter for further consideration on how soon can you come back? Next Tuesday?
If we are engaged in the second matter, we can come back by next Tuesday. If someone else is engaged, then
No, then someone else will take care. I am fixing it on next Tuesday. Yes.
The only thing, madam,
Yes.
Madam, tomorrow there is the last date for tender, madam.
One tender, there will be subsequent tenders. Tenders are floated on regular basis.
The largest of them, madam. That is why this has been.
Tomorrow is the last
Yes,
date.
madam. Now,
all
madam,
right.
Since your lordship's order is now being revived, madam.
I'll permit you to participate.
Kindly, madam.
All right. List.
Subject to the
List হচ্ছে 8 তারিখে।
I'll get it last.
ঠিক আছে, paragraph দিন। Learned counsel for the petitioners submit that tomorrow, কালকে date দিয়ে দিন। 2nd July is the last date for participating in a tender process. Is there a nomenclature or something?
Well, it's annex, my lord, just page 370, my lord, if your lordship kindly has a look.
All right. Being tender number 122414588.
8, my lord. Closing date is 2nd.
Page 370. The petitioner shall be permitted to participate in the said tender process. What is the date of opening?
The opening is
30th is
no, my opening date is not there. My closing date I find.
Yes.
Opening date, my lord.
Within 1 day of issuance of contract, the delivery and completion is on or before 25th of September 2026. Acha. The
opening of tender,
the fate of the petitioner's participation in the tender process in the subject tender shall abide by the result of the writ petition.
Is keeping it on the
next Tuesday.
Could it be on Wednesday or Monday? Any one of them.
Monday is the monthly.
Wednesday, Wednesday.
9th.
I'm not there on Tuesday.
Very good. 9th. রেখে দিন, ওটা ওর সাথে আছে।
Lord, I am appearing for the writ petitioner.
Yes.
Lordship, I have filed one application for addition of parties, Lordship. Lordship, what happened, Lordship?
Who is the petitioner?
I am the writ petitioner, my lord.
Who is he?
Lordship.
He is the contractor or what?
My lord, he is one of the.
Who are you?
I am one of the, my lord, participant, my lord, intending participant.
Intending participant.
Actually, my lord, what happened, my lord? That is, my lord, this is the NIT which was issued in the year of 2020, my lord. That is at page 65.
All right. Then what happened?
My lord, the said NIT was finalized.
21st May 25. Yes.
My lord, the NIT was issued on 12th May 2020 at page 65, my lord.
21st May I can see.
No, my lord.
65?
65, yes.
At the top, 21st of May.
My lord, that is on the date we have taken printout.
All right, you've taken printout.
Yes.
Where is the date?
My lord, date is, my lord, that is tender
12th of
reference
May.
number.
Right, I have seen 12th of May.
CMH BHD 770 dated 12th May 2020.
Yes.
This is the tender date. And my lord, the validity, bid validity period was 150 days.
Where do I
That is
get
in
that?
the next page, my lord.
Yes, bid validity
Yes.
date is 150.
150 days. And my lord, the contractual amount was, tender value was 2,14,20,000.
Yes.
And my lord, the said tender was finalized upon issuing a work order, my lord, that is at page 67.
Yes.
Award of contract. And my lord,
Tapan Kumar Chandra.
yes.
Who is he?
My lord, he is the present contractor carrying, supplying the cook
All
in
right.
the Vishnupur District Hospital.
Yes.
My lord, this Tapan Kumar Chandra has applied before your lordship for releasing from the from supplying the cook diet. Your lordship directed, that is also annexed in the application for addition of party in the page 12, my lord. This is the, my lord, this is the order your lordship passed.
No, if it is annexed, why are you handing it over again?
Yes.
Page 12, yes.
Page 12. My lord, your lordship directed.
Yeah, he is not interested to proceed.
Yes.
Right, then.
Then, my lord, they have to pass a reason order.
Yes.
In the meanwhile, what they have done, my lord, now, my lord, I am coming to the particular application for the addition of party, my lord.
I have not pressed it.
Yes, my lord, this is on the
I have
board.
Who is the applicant?
Lordship, I am
Shivaprasad
telling you, Lordship.
Banerjee.
Lordship, I was the second L2.
I'll hear him. I'll hear him.
I did not disturb you.
Yes, yes.
My lord, then, my lord, come to the page 14. Where
14 of?
14 of the can. Can 1.
Can is not by you.
Milord, because this is the Milord, this is an admission on the part of the Milord, kindly have a look to this, Milord. The COMH BID is addressing the particular Shiva Prasad Banerjee, who is one of the contractors, saying so. This is to inform you that in connection with the NIT bearing number such and such, the same NIT which I have annexed in the page 65 of my writ petition, that for supplying cooked diet of Bishnupur District Hospital and SSH, this is lowest bidder Shapun Kumar Chandra has expressed his inability to continue his service due to his ill health. In view of this, in compliance of the honor, my lord's order was not that to give the particular Shiva Prasad Banerjee directly to this. Have a look, my lord. Third.
What is the case made by you in the writ petition?
Yes, my case is that, my lord, the authorities are going to appoint third party.
And you did not implead the third party as party respondent? You did not know it.
To that, my lord.
Right now you know.
And now I have come to this, and my lord, there is an express, my lord. Kindly have a look to this can, my lord. This is an express.
Did you file the can?
I have filed one can, my lord.
This is application for addition you have filed?
No, sir, I have filed.
So you have not come forward with a case. The person in whose favor the authority intends to issue the contract has come forward.
Yes.
So let him be added.
Yes.
Right?
Yes.
Now what is your case?
My lord, my case is this, my lord. The authorities are going to issue work order in favor of the applicant in can 1.
Right.
And that is, my lord, at page 14.
Who is for the state? You are added.
Lordship.
Right. Now, what is your submission?
Yes. Lordship, may I clear one thing first, Lordship, because it will help, Lordship. Because, Lordship, as far my knowledge goes, Lordship, after your Lordship passes order, they discontinued the erstwhile contractor, and I stood L2 in the tender process, Lordship.
2020?
2020. I stood L2. So they have given me offer letter. Look, he has discontinued, willing to discontinue. Are you willing to? I have given my consent, Lordship. And thereafter, as the petition has been filed, they kept themselves silent, Lordship. The authority kept themselves silent.
And are you agreeable to the rate which was
Lordship,
prevailed?
Lordship, let me. As I was L2 at that point, so I have to accept, and I have given my consent, Lordship.
All right.
And Lordship, number 2, Lordship, the petitioner did not apply for that tender, did not apply, and he does not have that credential. Lordship, the credential requires after 2011, any 3 years, the credential is required 3 years service. He does not have. He has annexed his credential. It shows he does not have 3 years service.
Very well, I followed it. Yes.
Yes. Lord, my instructions are almost similar to what the Lord,
private respondent has said.
Because Lord, pursuant to your Lordship's order, the previous
Contractor has discontinued.
Has discontinued formally. The problem is, Lord, we had issued a offer letter to the applicant on 13th of May 2025.
All right.
But Lord, formally he has not been Lord, given the charge
Work
of
order.
the work because of the pendency of this application.
All right.
We only await the outcome of
You contend that the private respondent was the L2 in the earlier one.
That is my instruction, my lord. Private respondent was L2, my lord. There was another L3, my lord, who did not turn up and cannot be considered because L2 is here. And Minicon, my lord, the petitioner did not participate, so my lord, that participant.
Now, my lord, in reply to the counsel for this state, my lord, I am showing your lordship a notification of the state. That is at page 36, starting from page 36, my lord. And my lord, that is relevant portion is page 38.
Yes.
Applicable for intended value above 5 lakhs. I have shown your lordship that the tendering value is more than crore. and all works tender value above 5 lakhs proposed for execution through this contract document are to be notified and published in form of inviting tender NIT.
Listen, first of all, this
Yes.
was a tender of 2020.
2020.
You were not there in the scene.
My lord, first of all, I can be a prospective bidder, my lord.
As and when tenders are floated, you will
My lord,
apply.
this tender has already been concluded. Why I am saying so, my lord? The tenure of the contract was 3 years.
That is up to the authority. Who are you to say?
My lord, that has
Please come.
My lord, that is the tenure has already been, my lord, completed. Kindly
The
consider.
matter relates to supply. 65
Cook food.
relates to
Cook
My
food.
lord, my prayer is that they can
supply of cooked food
issue fresh
Bishnupur District Hospital.
in the Bishnupur District Hospital. Stuff. A tender was floated by the authority in the year 2020. Stuff. The person who was awarded the contract expressed his inability to continue with the work. Stop. A writ petition was also filed by the erstwhile contractor.
My lord, I'm not the erstwhile contractor.
I am not mentioning.
Yes.
Why are you interjecting? First, listen what the court has to say.
I'm apologist, my lord. I'm apologist. I have made mistake.
Don't be so over enthusiastic. I can see you were there in the earlier matter.
Yes.
Your idea was the erstwhile one will go and the new one will come in. This is not the way how the authority will proceed with matters. Right?
Notice inviting tender can be called for, my lord.
According to your choice.
My lord, that is the notification.
Right. Keep it with you.
The writ petition was also filed by the erstwhile
Contractor seeking for a direction upon the hospital to consider his representation for releasing him from the contract. Stop. Order was passed by the court on 25th February 2025 in WPA 1168 of 2025. Within bracket, Shapon Kumar Chandra versus the Director of Health Services and others. Stop. On receipt of the order passed, on receipt of the request, on the request, the authority accepted the request of the erstwhile contractor Shapon Kumar Chandra and proceeded to issue contract in favor of the L2 bidder in the tender process of the year 2020. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that the authority ought to float fresh tender for selecting a bidder and ought not to have requested and ought not to have offered the proposal to the L2 bidder in the erstwhile tender process for continuation of the contract. Stop. According to the petitioner, the contractual period has ended and the authority should float a fresh tender so that the petitioner, as a prospective bidder, could participate in the same. Paragraph. An application for addition of party has been filed by one Shiva Prasad Banerjee, who was the L2 bidder in the erstwhile tender process. Stop. Offer has been given to the applicant to express his willingness to continue with the work of supplying cooked diet. Stop. The applicant is agreeable to accept the proposal of the authority. Stop. the court finds that the presence of the private respondent is necessary for the purpose of adjudication of the instant writ petition, and hence allows the application seeking addition of party. Stop. The applicant be formally added as a respondent in the array of respondents of the writ petition. Stop. Paragraph. Learned advocate representing the state respondents submits that the authority has already offered the contract to the second lowest eligible bidder of the subject tender. And as the L2 bidder is agreeable to work on the same terms and conditions of the tender document, accordingly, the authority intends to accept the proposal of the private respondent. Stop. Paragraph. Upon hearing the parties, it appears that the tender process, which was initiated by the authority in the year 2020, continued till the contractor who was engaged expressed his inability to continue with the contract. Stop. The authority has offered the proposal to the L2 bidder and intends to continue the same. Stop. The court does not find any illegality in the stand adopted by the authority. Stop. As and when fresh bids are invited, then all eligible participants may participate in the tender process. Stop. Right now, there is no scope for interference in the instant writ petition. The writ petition fails and is hereby dismissed. Service is taken on record. Can 2টা কিসের ছিল? What was can 2? লিস্টে তো আছে, নাই বা এলো। It must be there. What was can 2? Any idea?
Can 2 is also filed by me, my lord.
For what?
For another bidder, my lord, who has been brought before your lordship. As the writ petition fails, nothing remains in this, my lord, because can 2 is also.
Bring the can 2. ঠিক আছে? Since the writ petition has already been dismissed, no further order is required to be passed in the connecting application number 2 of 2025. The same stands disposed of.
Your ladyship may kindly, my lord, record one thing, my lord, that can 2 has not been served on us.
My lord, can 2 is.
We do not have it on our records.
The court also doesn't have it.
Can 2 was filed yesterday only. Yesterday. Yeah.
Can 2টা আনিয়ে নেবেন. Tag it with the file. Can 1 আছে.
Item number 4, madam, appearing for the
Yes.
petition in
My
this
lord,
matter.
lordship's last order may kindly be referred to.
Paragraph 7, 8 and 9, 6, 7 and 8.
Paragraph 6, 7 and
Lordship has
yes, whether the seized goods are excess jewelry not reflected in the stocking trade cannot be adjudicated at this stage. Bank guarantee of equal amount. Asha. Right. What is the amount? Has the amount specified? Written instruction whether the seized can be released in favor of the petitioner. What is your written instruction?
My lord, the written instruction came that since there is no, as I submitted on the last occasion, since under FEMA there is no such provision for provisional release and there is no concept for redemption, even upon confiscation to redeem it, there is no such concept. So the authorities are not in a position to accept that because it will vest upon the government on confiscation.
So your prayer cannot be allowed.
Well, only two things, my lord, if your lordship.
Paragraph 6 was earlier this order.
Yes.
My
was
learned
there.
friend has submitted that these are disputed question of fact, as well as the excess jewelry was not accounted for. If your lordship takes my reply once, I'll just for my satisfaction.
Once a dispute is raised,
No,
will the court go into and enter?
I am the last person to go into the disputed fact.
Then
Lordship will kindly takes my reply. I have just quoted their show cause. Yes, just paragraph page 7 only. I'll
of
just
the
show.
writ petition.
Yes, no, my reply. Their opposition, my reply.
Affidavit in
Yes,
reply.
yes.
Page 7.
Yes, ma'am.
There is
If
a
your
chart.
Before that chart, lordship kindly takes paragraph 6, second paragraph. Third paragraph it starts. Why I am saying so, ma'am?
It is pertinent.
Yes, ma'am. It is further pertinent to state that it is evident from the paragraphs quoted below in pages 85 to 103 of the complaint filed by the ED that there is no fault on the part of the petitioners. On the contrary, the respondent authorities have failed to prove their claim. The paragraphs are as follows. I have just quoted the paragraph from page 17 to 14, in which that is their show cause notice, which shows that the unaccounted jewelry they are saying, my lord, they have said that I have already proved that it was through bank transfer, the logistic entry, the GST entries, all are connected.
These all are subject matter of
subject matter of trial. I'll come.
You are going to approach the adjudicating authority.
I have to, Now, in respect to second thing, the seizure has to be made under section 37 of the FEMA Act, wherein income tax act, procedural part has to be followed. And from that act, if I can show before your lordship, the stock in trade cannot be, retained by the authorities.
Peruse the written submission forwarded by the Directorate of Enforcement dated 30th of June 2025, clearly mentioning that on confiscation of the goods, the same stands vested in the government, free from all encumbrances, in accordance with the applicable statutory provisions. Such vesting extinguishes all prior rights, title and interest of any person in respect of the confiscated property. Under Foreign Exchange Management Act, 1999, there is no provision either in the Act or the rules for provisional release of the property once they are seized under Section 37. Paragraph. In view of the submission of the authority, there is hardly any scope to entertain the writ petition any further. The writ petition stands dismissed. Dismissal of the writ petition will, however, not stand in the way of the petitioner to approach the adjudicating authority with their prayer. Next. In the event with their prayer, it's over. Nothing.
The petition stands disposed of.
Yes. Because of disputed questions of facts, the court is not entering.
Your lordship is granted us the liberty to go back to them and pray.
Yes, it is made clear that the court has not entered into the merits of the matter at all, and the writ petition has been dismissed only on the ground of existence of disputed questions of facts. So all points are left open.
I'm for the petitioner.
In
this matter, your lordship, that 6-page commission report.
As far as your lordship's last direction
Place
is
it on the
concerned.
website. Now, they have placed it on the website. Some pages are missing.
Some pages are missing.
Missing.
Your learned friend will supply the
But I have given
pages.
the
entire link. These are huge, voluminous documents.
Okay.
I have given the links.
Give a copy to your learned
I
friend.
have. They already have in the website. I wish again.
No, all the links are, whether their links are there or not, please check.
Yes.
The pages that are missing.
And your lordship will kindly see one provision of the RTI Act.
What provision?
6, Section 7, Clause 6.
What?
Kindly see that.
See what is there?
It is there that as they have admittedly delayed
in
for 3 years in 2022, I'm entitled to a free copy of that.
But this is a voluminous copy. It has been uploaded in the website. Please collect it. I'll keep it pending. You just check whether the links are opening and whether the missing pages are available or not.
I'm also entitled as per the RTI compensation.
I am aware of it. You please check up whether all the pages which you say are missing are available or not.
I can give the page number 154.
He says those are voluminous documents. The links have been provided. Please see. I'll keep it when? 2 o'clock?
What?
2 o'clock?
Sir, দেখে বলতে পারবেন?
Just check up and see.
I've checked out now only a few moments back. 140.
There are links provided. Are you clicking on the same?
My senior friend says they have checked it and they know which are the pages they
101.
Kindly records and disposes of. We will provide them the pages.
2 o'clock I'll dispose of. Please check. If it is there already, what is the use?
Even if it is not there, we will provide the pages.
Will not keep all those points open. Everything will be set at rest once it's disposed. Please see whether the pages are there or not. I'll take it up at 2 o'clock. And you please help your learned senior friend to open the link and show the pages. Yes. 6.
The 6. I beg to appear on behalf of the petitioner. Malata, twice your lordship directed to file a report with regard to the release of the fund. The release of the fund with regard to the financial help for making the construction. So now the lordship kindly see the last order. So I also inform Mrs.
And some of the eligible to the report.
I sent the message in just few minutes back also to call.
Please come. Can? Who are you? For the applicant?
Several other persons. I want the same footing as Mr. Andar's clients.
But then why was it a joint application?
My lord, this matter, my lord, I have no objection. Because of that, we made an application jointly before the authority concerned. Pursuant to the order of the district magistrate, an inquiry was conducted by the, my lord, the jurisdictional panchayat twice. So now it is found that out of 35, my lord, the beneficiary, 20 beneficiary, more or less, my lord, 20 beneficiary are eligible. Out of them, my lord, 5% have come before your lordship, and rest of the, my lord, 13%, they have come with since our application has been conducted. So I have no objection if your lordship the application.
Where is the application? Where is the application? When did you file it? Jana Babu, list application আছে সেটা How many are there? 13 applicants. Seeking addition of party as they claim that they lie on the same footing as that of the writ petitioners. So, the petitioners doesn't have any objection with regard to the application that has been sought for. Stuff next. In view of the above, the applicants in Can 1 of 2025 be added as parties in the instant writ petition. Stop. Paragraph. it is very disturbing to note that despite repeated opportunities granted, repeated information served upon the learned advocate for the state, the counsels are not present. Stop. Next. In such a position, the court is constrained to request the learned government pleader to engage any other counsel who may make himself/herself available before the court with necessary instruction as and when the matter is called for. Stop. Let this order be communicated to the learned government pleader. Stop. Released on 8th of July.
My lord, 8th.
Can disposed.
9th, my lord.
9th.
9th, my lord. I'm grateful to losses.
9th.
Grateful to loss.
Lordship, Mr. Siddhartha Banerjee is appearing in this matter. I'm praying for a short passover. He is in the next court. Short passover.
For whom is he appearing?
Petitioner.
For the petitioner. You are for the state. Very well. I'm passing it over.
Fine.
Yes, call the next one.
Number 8, I'm for the petitioner, Lordship. On the last occasion, there was a direction upon the state, Lordship, to produce the employer details of the private respondent. Lordship said application under the maintenance of senior citizens and guardians act, Lordship. And that application was filed. The private respondent, being the son of the petitioner, did not appear.
Is anybody there for the private respondent? You are there? Yes. You are not taking care of your mother. No, she only wants maintenance from you. She is a senior citizen. This is the submission. Do you say that she is not a senior citizen? She is not a senior citizen.
This petition of 2024, an endeavor was made by her. The first to attend service on the address recorded here.
Without going into anything, since you are there, are you taking care of your mother or not?
There is no question of taking.
All right. Why?
There are reasons.
She is not your mother.
She might be my biological mother. She has
But
not
then
disclosed all these facts. I'm handing it over to my learned friend. Will not mind. I am representing Obitgan. Obitgan is presently sailing in the Atlantic Ocean.
All right.
He is a sailor.
Yes.
His wife is present in court. The police is regularly barging. Not in their residence, with constables and everyone, just
yes.
And what has been served on her is this particular document, apart from anything else. This is original document.
These have come returned, Lordship, from the
yes.
Copy of the petition that was served. She denied service.
This is immediate communication, I'm handing over to my learned friend also. This is what the police served on me.
What is there? Please say. Please say what is there. Yes.
The father and my mother, they were married long time.
Right.
Was raised up by my maternal grandfather.
Right.
I was raised by my maternal grandfather. We used to stay in an apartment near like Bonopur. Now, my mother decided to part ways with my father. And they started living separately without, of course, any legal divorce. They started living separately. She started living with her own companion, in a different apartment. Which incidentally in 2005 out of my funds was purchased by me in 2005. Now, after 2005, she said that it is not possible for her to stay with us, and it was mutually agreed that the flat would be put on sale, and whatever the funds derived from therefrom would be shared equally between me and my mother. she accepted the funds. She had no contact with me till 2023, 2024, when Milord first, Milord, this SDO's notice or whatever was sought to be served, through which Milord I informed the police and everyone as a law-abiding citizen on my return to the country that this is the factual position. I am not available in the country. Whatever is to be done has to be done subsequently. The SDO's order apparently says that since the private respondent is not available, nothing can be done. Now, today the position is, she's.
Are you willing to provide maintenance? She is your mother, and the act says you are to do it.
Apart from being my biological mother, she has done. I mean, I have no personal ties with her.
She is currently very sick. She was found in sick condition. In fact, she was rescued. She was rescued.
She is presently in a home, Lordship.
She is there staying in a home.
Was living with a person by the
Whoever, the court doesn't want to enter into all these things. From records, it appears from the Office of the Human Rights Initiative.
All these facts to your Lordship. Has she disclosed this fact that she has?
She is not in a position to disclose.
She is in a position to disclose.
I do not know. The records say she is in a home.
Just of respect, she is not in a position to disclose. Maybe she cannot move for whatever ailments, but it is not a question of she is not able to speak or she is not able to communicate. We have conversations, with the son, when he was in India, when the conversation transpired to this extent that what you have to do for me. The only thing is extraction. Only purpose behind everything.
Where is she now? In the home?
Yes, Lordship. She's
Which
in a
home?
it is somewhere in Kalyani, Lordship. That is why the complaint was raised.
Old age home at B14465 Kalyani.
Yes.
This person is not one who has affirmed this affidavit, the writ petition, and some Mr. Bormon. They are apparently taking up her cause, seeking to communicate with me, and the only purpose is extraction. Because I am a sailor, I have my own family, I have 2 children. She has not been a party to my marriage. She has never seen my wife also practically. Today,
who takes care of her charges of the home?
Lordship, that is the home is it's human rights initiative. It is an NGO, Lordship. They are taking care. There's no money that is being paid to them.
No money
Lordship,
paid.
that is why they made the complaint.
How much is required?
It is just her basic maintenance and the medical expenses.
How much?
That I have to take instructions. Not a much amount, Lordship. It is there. My complaint is at page 13, Lordship. This is the first complaint to the SDO, Lordship.
Yes.
Just for basic maintenance and everything, Lordship.
I cannot read this complaint. This was not been served on me.
We'll provide a copy to you. Or you have a copy.
Several times. Yes, I
You
have
have a copy. Give
the
it.
one that was refused, I can.
Yes, give it. Give it to him.
This is still
Right,
Lordship. That came
Yes.
returned.
I'm tearing it in front.
Yes. The
Copy of the writ petition was there.
give a figure that will be required for the basic maintenance.
Basic maintenance, food
Medical.
and only medical expenses, Lordship, because she is
Yes.
very ill and she is
So
unable
that
to.
the money can be directly forwarded to the home, and the petitioner also will not be receiving anything on her own, and the money is not required to be handed over to somebody. It will go directly to the home, so that her charges can be taken care of.
Lordship, kindly sees at page 13 the address and everything. I came to know from a source about Shankar Prasad is a member of Human Rights Initiative. Somehow I could manage to contact him and explain my difficulty. He rescued me from Bonaful Abashan to Kalyani Old Age Home, B14 465 Kalyani Nadia. This is where she is now, at this home.
What is the age of this lady?
She is nearly 70s, Lordship, in her 70s.
68 years.
68.
Nearing 70. Anyway.
I would not most earnestly, your Lordship will pass the orders, whatever your Lordship wants. Kindly takes the pain. He has communicated with the advocate and the court. I don't even have the wakalatnama.
Please come.
Apart from
the respondent number 5 has entered appearance to the learned counsel. Stop. It has been submitted that the respondent number 5 is a seaman and is currently sailing. Stop. Next. The wife of the respondent number 5 is reported to be present in court. Stop next. It appears from the submission. Now, learned advocate for the petitioner submits based upon the annexures that the petitioner is currently staying in an old age home and there is none to take care of her basic amenities. That's an old age home run by an NGO. Stop. Next. The petitioner seeks maintenance amount only for her survival. Stop. Learned advocate representing the private respondent, that is the son of the petitioner, submits that apart from being a biological mother, there had never been any relationship between the petitioner and the private respondent. Stop. The petitioner never took care of her son. Stop. However, without entering into any dispute with regard to the mother and the son, as it appears that the son is financially well off and the mother is left in an old age home with none to take care of her basic needs, the court is of the opinion that the son be directed to pay an amount which would be required for providing the food and medical treatment of the petitioner. Stop. The amount may be directly transferred to the bank account of the NGO running the old age home where the petitioner is currently staying. Stop. The amount which will be required for the for taking care of the basic needs of the petitioner shall be intimated to the court on the adjourned date by the learned advocate representing the petitioner upon obtaining information from the old age home. Stop. Next. I'll keep it next Wednesday.
Not sure.
9th. Released on 9th.
Only one.
Basic medical needs.
Your Lordship's order does not say, it says medical needs.
It will be basic medical needs only for her survival. You cannot throw a lady outside in this manner. I'm not looking into anything. You can take this back. You can take this back. I am not inclined to read it.
It's not an endeavor to wash linen in public, but at the same time, of respect. Though she is my biological mother, I do not want to do it. There are reasons. There are definite reasons.
Yes, call the next matter, please.
হাত বাড়াচ্ছেন কেন সবে তো করতে দিল নাকি নাকি দিয়েছে খুব
appearing for the petition. The last occasion, my Lordship has directed my learned friend to file a report.
Do I get a signed copy?
Yes, file it. Something has to be.
Authorized or something.
Thank you, ma'am.
My learned friend is supposed to file a report today, my lord.
At a line legal in tale leave granted to the learned advocate representing the private respondent to file the wakalatnama in the department prior to the adjourned date. I have given you leave to file it in the department prior to the adjourned date. Wakalatnama. I understand. You check up. If there is any difficulty, please mention. Yes.
The last occasion it fell from your lordship that my learned friend will file a report whether the SDO has started initiated any proceedings or not. On the basis of
what happened, my lord, the petitioner and the private respondent all belong to within the jurisdiction of Alipur police station, and the Alipur police station come under the assistant director of social welfare, having office at Sashi building, Salt Lake, sector 1. They have to approach. They are not the SDO Alipur.
Here SDO will not be the authority, the
No,
district
SDO
social welfare officer.
Alipur police station, Alipur falling under that jurisdiction, my lord.
I'll give the address.
My lord,
Why don't you transfer it to that authority? You can do that.
there is no provision of transfer, my lord. They have to make the application there. They will entertain, my lord. 18.
এই বইটা কোথায় গেল?
2007 Act.
ওয়েলফেয়ার অফ সিনিয়র সিটিজেন্স বইটা কোথায় গেল? দেখুন দেখুন এখানে আছে। কালকেই তো ছিল এখানে, এখানে যে বইটা ছিল, হ্যাঁ ওইদিকে সরিয়ে দিলে আমি কি করে? আরেকটা আছে, আরেকটা আছে। ইয়েস ইয়েস ইয়েস। The maintenance tribunal is the state government shall within 6 months constitute a tribunal.
Well.
Constitute for each subdivision one or more tribunals.
Yes.
Right. And the tribunal shall be presided over by an officer not below the rank of this SDO of a state.
Yes. There are few tribunals, my lord, where, my lord, certain police stations have been demarcated that this tribunal will take up this. But I have a list I can hand over to your lordship, where the assistant director social welfare, Salt Lake, is taking up the Alipur police station matters. May I hand over the list, my lord?
Yes, yes, you can give the list. But thing is, if there is already a complaint, will you wait for somebody to approach the court? And will the authority not pass it on?
Found out any provision of transfer, my lord.
This is not a question of transfer. It's just like an FIR. When it is filed, where the person concerned wishes, but it has to be transferred to that person, sent, forwarded. Transfer it, it is not in that sense, but it has to be done.
CL
Yes,
44,
directorate.
right hand side, 44.
Alipur.
It's Alipur, but
Assistant Director, Directorate of Social Welfare. See,
Taisali Building, Salt Lake, Sector 1.
the state government shall designate the district social welfare officer not below the rank of the district social by whatever name, the maintenance officer.
It should be serial number 47, New Alipur.
Very well, 44 or 47, whatever it goes to the assistant director. Please come. Learned advocate representing the state respondents submits that the petitioner is required to forward her complaint before the assistant director, Directorate of Social Welfare, West Bengal, at Shoishali Building, Salt Lake, Sector 1, Kolkata 700064. Contact number 033 2479 3940. এখানে আছে, হ্যাঁ। Stop. The court is left wondering as to why the subdivisional officer who received the complaint from the petitioner did not forward the same to the competent authority. Stop. The complaint of the petitioner was received by the office of the district magistrate
29 November.
The subdivisional officer, Shodor SDO Alipur, what is the middle seal in the in page number 35?
Welfare.
Right. The district social welfare officer, South 24 Parganas.
Well.
But none intimated the petitioner that her request under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007 is to be considered by the Assistant Director, Directorate of Social Welfare, West Bengal. Stop. The aforesaid authorities ought to have advised the petitioner, who is a senior citizen and requires maintenance from her children, with regard to the appropriate authority where the request is to be lodged. Stop. The aforesaid authorities ought not to sat tight on the complaint lodged by the petitioner, compelling her to approach the court for relief. Stop. The authorities ought to act in a more responsible manner. Stop. Paragraph. The instant writ petition is disposed of by granting liberty to the petitioner to approach the authority mentioned herein above, who, on receipt of the request from the petitioner, shall take necessary steps to redress her grievances. Writ petition stands disposed of. Acha, grievances in accordance with the act as mentioned herein above. Disposed.
My lord, one indulgence, my lord. Since this, my lord, one indulgence, my lord. Since this complaint has been made in 29/11/2024, my lord.
Yes.
Could I forward the same complaint or again I have to?
Whatever, you can choose. If you wish to add something, you can make fresh complaint. If you want this to be forwarded, it is up to your choice. I leave this upon you. Next.
I beg to appear for the petitioner, my lord. But pursuant to your lordship's last direction, my lord, may I file the supplementary affidavit, my lord?
Yes. এই বইগুলোকে এখানে রেখে দেবেন
Forward করে দাও না।
পরে রাখবেন Yes.
My lord, this is a writ petition, my lord, if your lordship recalls, my lord, where I have challenged, my lord, the cancellation of the auction of a property which was done in my favor. Your lordships then directed SEBI to consider my representation, wherein a final order, without even hearing me, my lord, was passed, although it's recorded in the order that I was heard substantially, but no representation has been called for. And there's a now.
What do you mean by representation has not been called?
But I have not been given an opportunity to hearing, and I'll, my lord, demonstrate from.
Present at the time of hearing.
My lord, we were present. We were, my lord, called, my lord, by SEBI to, my lord, discuss on the possibility of extending, my lord, allowing my deposit, my lord, which was already made, to be considered. And while the discussion, my lord, I find, my lord, after 2 days that this particular order was passed.
Then
and this
they
order was.
have waited for 20 days or what?
Well, my lord, I'll indicate, my lord, your lordships had already passed an interim order in my favor, my lord. But I'll just, lord, kindly permit me to just face the facts, my lord. This is, my lord, a writ petition.
One minute. What is the stand of SEBI?
If I may, Your Lordship. Your Lordship, this is a case where
There was a day's
Yes,
delay
your lordship,
in
there was
making
only a day's
payments.
delay, and your lordship asked us or directed us that if 1 day delay can we condone, your lordship. Your lordship, my stand is that, your lordship, we do not have the power. However, I have gone through a few cases where even though the recovery officer do not have the power under section 28A, however, if it falls from your lordship, then we can definitely oblige by it and we can do it, your lordship. This cannot be recorded, your lordship, but however, I'm telling you
I
because we have
understand.
seen cases where such
Yes.
issues have happened and we have condoned the delay.
Right.
Yes, your lordship.
Now, when was the deposit made?
Your lordship, the second deposit was made on 4th of December, and as per the timeline, it was supposed to be made on 3rd December 2024. So there was only 1 day delay, your
But
lordship.
there's certain incorrect facts which has been stated. Malad, kindly let me permit Malad to place two documents.
Just give me the date.
Plus 2nd
and
of
the-
December. The entire payment has been made on 2nd of December. The payment which my learned friend is alleging is a commission which is called poundage fee of 1%, which I paid on 4th December, which is within the period of 15 days as stipulated in the tender terms and conditions.
All right.
However, your lordship, we are
And
ready
this
to
rule was changed after I was declared as the highest bidder.
Supplementary affidavit filed by the petitioner in court today is taken on record. Stop. It the order passed by SEBI on 30th May 2025. Recovery officer SEBI. ঠিক আছে? 30th May 2025 is annexed therein. Stop. It appears that that SEBI contends that the petitioner was delayed by a day in making payment. Stop. According to the petitioner, the payment was made within the stipulated time period. Stop. Paragraph. On hearing the parties, it appears that a single day's delay, if at all, may be condoned by the authority to save future efforts on the part of SEBI to sell off a part of SEBI to conduct fresh auction for selling of the secured asset. Stop. To put at rest the issue of sale, comma, the authority, not authority, SEBI is directed to accept the payment of the petitioner and take necessary consequential steps in the matter. Stop. The what are the steps to be taken? Now you'll say
What we
sale
have to
certificate.
the sale certificate. I mean, what I think
Whatever
the
is
sale-
to be done, I
whatever
have
the
mentioned
necessary
all
steps.
consequential steps.
We will oblige by that.
Yes, please do. The writ petition stands disposed of.
But may I make, Malad, one humble prayer, Malad?
Yes.
Insofar as the order of the recovery officer is concerned, Malad, that may be, Malad, set aside.
Where is it?
Malad, that which I have annexed at page 5 of my supplementary affidavit.
All right. The order dated 30th May 2025 passed by the recovery officer stands set aside.
I'm great.
Disposed. Next.
Oblige, your lordship.
For the petition in this matter.
Yes.
The matter was taken up by your lordship yesterday. There is directed to file a report.
Yes,
This
yes.
is my your lordship kindly speaks the order of 16th of May 2025. 16th of May order.
Yes.
Step 3, this is my contention. Your lordship specifically mentioned. This is a second out of petition. Petition is a retired teacher. There is a cow farm Run by the private respondent.
Oh, single cow, single calf.
Let them remove, let the
Why, domestic animal, my in remote village, my lord.
I have my lord the pictures of these, my lord. Kindly see, my lord, these pictures, which is, my lord, this is the pond at the initial stage, and now this is subsequent stage. My lord, let him set up his, my lord, my lord, this cow set in his, my lord, nearby his residence. How it is done, my lord, kindly see.
কি ছবিটা কি কচুরি পানা হয়েছে সেটা কি
Last. This is not just, my lord, beside these cow farm or, my lord, set up just beside the, my lord, my pond, and, my lord, by which, my lord, that has been polluted.
No, that is a wrong submission.
And I have annexed, my lord, I have
One
put the
cup, my
photograph
lord.
also.
Please come.
You please remove it.
Kindly consider the last
Last
but one page, my lord.
Last but one page.
My lord.
May I get a copy of the, my lord, report, my lord?
Lord, this is the soak pit where the cow dung is being deposited.
This is the photograph, kindly see.
Yes. This has been constructed by the Panchayat authority.
1 feet.
In hearing held, in his presence,
You can only
hearing
remove it, and, my lord, his setup is nearby his residence.
Please come.
May I get a copy of the, my lord, report?
in remote village, one cup, my lord.
Yes.
He is run, my lord.
Peruse the
No, my lord,
report of the block development officer, Mathurapur 1 development block, signed on 10th March 2025, wherefrom it appears that various awareness generation programs are conducted to manage the grey water in the locality. Stop. Volunteers from the vector-borne disease control program regularly carry out duties in the area. Stop.
You are not
A
found
soak
on it.
pit has been constructed by the panchayat to manage the grey water. Stop.
I have the 2 photographs. You will also kindly see that.
The inspection report mentions that there is a drainage system near the cowshed to manage the grey water of the hamlet, and it has been found that the waste generated from the cowshed is not polluting the pond. The officer in charge of the pollution control board of the area has been instructed to take necessary measures to manage and mitigate any pollution which exists because of the cowshed. Stop. Next. In view of the above, the court is of the opinion that the respondent authorities should keep regular vigils to ensure that no pollution occurs at the said place in view of the cowshed, which presently has only one calf. Stop. The writ petition stands disposed of.
I have the photograph. You will also kindly see this photograph.
Yes.
May I get a copy of the report also?
See, everything is mentioned in the order. What extra will you get?
May I just place the photographs?
No. Call the next one.
12 by appear for the petitioner.
Yes, please.
My lord, this is the matter. If your lordship recalls, my lord, a particular tender has been floated in such a tailor-made way to keep the entire MSME sector out of the purview of participation.
Right.
Your lordship, by an order dated 16th of June, my lord, had directed me to file a supplementary affidavit, my lord. It has been served on the other side, and my lord, granted, and my lord directed them to take instructions on this particular, my lord, information whether the MSMEs have been kept out of purview of participation or not. So they are supposed to come with the
Are the MSMEs participating? They are?
Yes.
Yes.
How can they participate if the
Yeah, for all, my lord.
minimum amount,
একটু দেবেন কি দিলেন
whether MSME is subject to anonymous program?
একটা কপি দাও।
We carried out for revised specification.
It is brought to our notice. Fourth line.
Yes, does not fall in the list
Brought
of.
to our subject item does not fall within the item reserved and to be procured by from MSC forms as per MSME Act. The tenders has been issued in open tender and is available for all forms of the participant, including MSME. Attention is drawn in clause 11 and other conditions. My lord, kindly say clause 11.
Clause 11.
Page 189 of the writ petition.
This will answer all your queries.
Page what?
And the MSMEs are participating.
My lord, cannot. My lord, the tender value, the tender amount is 170 crores. If you take 150% of the tender value, it comes to 255 crores. Kindly look at the MSME Act.
You are
25 tenders already been participated.
and purchase preference is there, EMD exemption is there, everything is there.
The instruction.
It is there.
My lord, the instructions to tender. My lord, may I get a copy? May I reply to this?
Still to challenge.
May I get a copy, my lord? May I?
am supported by judgment of the.
Very well, my lord. I also have judgments to show, my lord.
Please
I am
come.
supported by.
Give a copy to him.
Yes.
Please come. Peruse the instruction forwarded to the learned counsel of the
Yes, I am.
railways, wherefrom it appears that the subject tender is open for participation by the micro, small and medium enterprises. Stop. All benefits under the MSMED Act are available to the MSMEs, including exemption of depositing the earnest money deposit and the purchase preference of 25% tender quantity to the MSMEs lying within the L1 plus 15% price band. Stop. 25 bidders
Have already been participated.
have participated in the tender process, including several MSMEs. Stop paragraph.
Next paragraph.
The petitioner contends that the authority has fixed the terms and conditions in a tailor-made manner to keep the MSMEs out of the tender process. Stop. The aforesaid contention of the petitioner does not appear to be proper in view of the instruction forwarded by the Deputy Chief Material Manager /E. Stop. Next. It is settled law that it is for the authority to fix up the terms and conditions of the tender, and a bidder hardly has a right to make suggestions for the purpose of fixing up the terms and conditions. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant.
Your lordship kindly grants
The
me an
writ
opportunity
petition
to
failed
revert to this, my
and
lord.
is hereby dismissed.
My lord, kindly gives me an opportunity to revert to this, my lord. They have referred to 2.4.1. Kindly cease of the ITT instructions to tenderers. My lord, absolutely.
All item 13.
My lord, this instruction, my lord, had no basis at all.
I am for the petitioner.
Your lordship kindly grants me an opportunity to, my lord, submit my views on this.
Item 13. Who's for the petitioner? Yes, what is it? None represents the bank. Is anybody representing UCO Bank? Yes.
Lordship, I am the widow of the son of the alleged borrower, Lordship.
Widow of the son of the borrower, all right?
Alleged borrower.
Hmm.
Lordship, my
Alleged borrower?
Lordship, the loan was not known to me, Lordship, because my mother-in-law died in the year of 2015.
May not be known to you, but your mother-in-law took, so don't say alleged.
In 2020, Lordship, one sale notice was published. I have seen
Yes.
that, and thereafter I gone to the bank. I have asked them. My husband also died in the year of 2019.
Yes.
As per the sale notice, Lordship, I have seen the notice under section 13(2) of the Surface Act issued in the year of 2018,
Yes.
whereas my mother-in-law has been died in 2015, and the sale was fixed. I have tried to settle the matter. Bank did not respond to my prayer, Lordship. I have sent a letter to them in the year of 2024. No documents has been served to me. Nothing has been served, Lordship. Lastly, in 2015, 18 June, 2025, 18 June, Lordship, they have page number 32, Lordship. They have issued one notice in Bengali without stating any law, any act. Lordship, they are trying to vacate me, disposes me within 15 days from this notice.
Yes.
Lordship. So, as per
What
the
is your instruction?
Kindly see page 25. He
Yes.
had a copy of this notice, sale notice, issued in 2021.
Hmm.
Now, after the amendment of 13(8), nothing remains. In 21 gone.
I don't know
Has the property been sold?
It has not been sold, but after
It has been put up in auction.
once the first auction comes in, right of redemption goes.
Lordship,
Yes.
this is the
So it's over.
wrong submission, Lordship. This is a settled
come.
law, Lordship. I am relying on one upon judgment, Lordship, of the
What judgment?
Lordship, kindly see, without giving the notice under the Surface Act to the legal heirs, bank cannot proceed, and bank has to give the notice.
Whoa, did you make the bank aware that the loan has
Lordship,
expired?
yes, Lordship. I have
All right.
kindly see the my representation. Dated 26th February 2024, page number 27. And if the sale was failed due to want of bidders, then secured creditor has to publish and has to intimate the legal heirs again.
All right.
This is the judgment, Lordship. Kindly see the paragraph 2.
The petitioner is aggrieved by the
My lord, kindly see the
steps taken by the bank to recover the loan amount
and the
under the
notice
provisions
notes
of the Surface Act. Step paragraph. The according to section 17 of the Act, any person aggrieved by any steps taken by the secured creditor to recover the loan amount ought to approach the debts recovery tribunal for relief. Stuff next. In view of the above, no relief can be granted to the petitioner in
This
the
notice is
instant
not
case.
under the Surface Act, Lordship. Kindly see the imping notice, Lordship.
Writ petition fails
I
and
cannot
is
go
hereby
before the DRT, Lordship. Kindly see, Lordship.
dismissal
page
of the writ
32.
petition will, however, not stand in the way of the petitioners to approach the competent forum for relief, if so advised.
Lordship, this notice is not belongs to under the Surface Act, Lordship. Kindly consider my situation. Lordship, kindly consider my situation. I cannot go before the DRT, Lordship. This is not the Surface notice.
You are putting a spanner on yourself. You can always go there.
No, Lordship. Without this Surface notice, how can I approach the DRT, Lordship?
Anyway, I'm not here to advise you. Yes, 7, who's there?
Said by Mr. Siddharth.
Where is he?
He's coming.
Coming from the morning till now, he's coming.
He gave me a
Let him come.
I can start if you Lordship want.
Great.
2 p.m. Lordship.
Now,
Yes. Only out of about 1,000 pages, only one page has been found missing.
I stated that page is
I will
still
provide
missing.
that. Well, there is no point keeping this pending. I'll provide that. Kindly gives me a time of 7 days or 5 days. We will provide hard copy of that particular page. Rest, I
how
believe.
come one page got
Well,
missing?
most probably it's a technical fault because of uploading so
Uploading?
many pages, scanning,
Other page
and uploading.
101 was also missing, but it has now been.
It's
put in.
there.
But 142 is not.
Only one page, 142.
1/4. Please come.
And your lordship will kindly consider regarding compensation 5 years.
No.
Compensation.
Mm, it appears from the submission made on behalf of both the parties
My lord,
that the information sought for by the petitioner has since been uploaded in the official website of the authority in terms of the direction passed by the court. Stop. Paragraph. Learned counsel for the petitioner submits that page 142 of the documents that have been uploaded is not available. Stop. Paragraph. Learned advocate representing the state respondents shall make the aforesaid document available to the petitioner positively by a week from date. Stop. The writ petition stands disposed of.
your lordship, there is one another problem. Your lordship will kindly see.
Yes.
They have uploaded. The other parts have been given the memo number and the date, but the bottom parts have not been. No memo number, no date is there.
You say the bottom and the top memo numbers will differ?
No, yes. The different parts have been given different memo numbers.
All right. So if it is there at the top, it must be
No,
there.
no. All different parts of that report
Yes.
has been given separate numbers.
Yes.
Circular number. But some of the parts have, there is no date, no memo number. Can you see that?
Whatever is there has been uploaded.
Now,
If there is any difficulty, you have to, that is a fresh cause of
May
action.
I clarify? This is a part of the report. There are certain circulars, certain memos,
Yes.
and there are annexures also. Those annexures need not be memo. There be no specific memo numbers. Those are part of the entire report. But whatever were there have been uploaded. Now, if one page is missing, we shall definitely.
No, that is all right.
Well,
But then the
Kindly
memo
see
numbers.
that. Kindly see that.
Listen.
That is their official
This
website.
court was only here for providing the information which has been supplied. The matter ends.
Yes.
Thereafter, you have any further issue that is
With
fresh cause
regard
of
to the
action,
report.
you have to challenge it
Yes.
My lord,
for the
only thing is,
competent
my
forum.
lord's, direction is probably on me or on us. May it be on the department concerned because
Why don't you take the responsibility?
we can definitely, but
Yes.
since it's a time bound, we
1
will
week, get it from them and pass it on.
Well,
Because from the department, again, a memo number will be generated, a forwarding letter will be generated. It will never come. You obtain a soft copy, make a printout, give
Yes.
it to your learned friend.
I
The
don't
matter
like that.
ends.
It can be shared by WhatsApp even now.
Okay, WhatsApp, it can be done. I can give
Even
it to
now it
him.
could have been, but
Sure.
let's say it's a technical thing. We need to take it.
Yes. You are not getting it and you think they'll pass it on to your learned
Yes.
friend. They will not do it within the time. That is the reason the court has faith on its counsels.
My lord.
Yes. Great lord.
But I have to change the side. I have to
Side?
change the side.
Always welcome. Any side.
My thought point is that I am a wife of an Indian citizen. I am not an Indian citizen. I had applied for OCI status on the basis of my marriage with an Indian. My lord, my first application was closed without assigning any reason. My lord, that was in 2022.
My lord, I am not troubling with your lordship with the documents, but the next application, which was in 2023, appearing at page 40, এটা 40, no. At page 52, says it is under process. It is as it is from 2023. There has been no disposal of my application. I only want, if they have to reject it, allow it, whatever be my OCI status, I am entitled to get on the basis of Citizenship Act, on the basis of my marriage. They must provide me some reasons. But every time I come to India,
Respondent.
I'm for the opinion respondents, my lord. My instruction appears, my lord, that the wife of the ex-wife of the husband of the petitioner has filed a case against both of them, stating that the ex parte order passed by the court.
Whatever, I'm not going into the merits.
That is
Tell me how the
pending, madam.
petition is maintainable. Article 226, as the instance of the Russian citizen, how is it maintainable in this court?
well, because I am residing in India and the cause of action of on this point, I was.
Check.
Then let me.
Apart from Article 21.
Yes.
No other article can be invoked by any other citizen apart from an Indian citizen.
Well, I am in a. I am having a valid visa.
Maybe, but then none of your fundamental rights are affected. Please check. Article 21, an exceptional
this, but I shall definitely check.
I have faced this. I have personally faced this.
I shall definitely try to satisfy your lordship.
The petitioner is a citizen of Russia. Stop. She has applied for an overseas citizenship card.
আমি এটাতে রেডি ছিলাম, ঠিক আছে, আমি করে দিচ্ছি।
Which is pending disposal. Stop. Paragraph. Learned advocate for the petitioner is directed to come prepared on the issue as to the maintainability of the writ petition at the instance of a Russian citizen. When? Next week?
Yes.
Wednesday?
Yeah.
No tarik.
Affidavit of service.
Affidavit of service. Who has not accepted this?
He accepted.
Commissioner of Immigration, Bureau of Immigration. Take the writ petition back. Affidavit of service is taken on record. The unserved copy of the writ petition addressed to the Commissioner of Immigration is opened from the envelope and returned to the learned advocate of the petitioner, retaining the envelope. 9th.
I appear for the respondent bank.
Dismissed. Give your appearance, please.
Lordship, I am appearing on behalf of petitioner. Lordship, this matter issue has been resolved, my lord, in this matter.
Very well. Learned advocate.
The
Learned advocate for the petitioner submits upon instruction that the dispute in question has been resolved. Stop. Next. In view of such submission, the writ petition stands disposed of. Record your appearance.
I am for the petitioner, my lord. This is my affidavit of service.
Yes.
My lord.
What is the
regarding my lord, the encroachment of the higher similar order passed by your lordship in the similar encroachment matter, my lord.
Where is your complaint?
Complaint, my lord. Kindly come to my lord. Page, my lord, 28, my lord. Page 28. দুটো অর্ডার চলে গেছে, একটা ফেরত দিন। দুটো অর্ডার চলে গেছে, দুটো চলে গেছে, দুটো গেছে, একটা দিন, একটা।
Where is page 28?
Yes, my lord.
Where is the proof of service of this letter?
Kindly next, After deed, my lord, after deed and all, and it's page 39, my lord, page 39, 30, 40, 41, no, all item delivered at this, all item delivered at this.
Who is for the state?
Well, I'm for the state.
What is the instruction?
But we have sought for the instruction, my lord, but the highway authority is not appearing, my lord.
Which highway authority is not appearing?
My lord, I have sought for the instruction.
Which authority is not giving you the information? Please tell me.
But
From whom did you seek the information?
my lord,
Whom? From whom did you seek information?
Four, the executive engineer, Murshidabad.
my lord, the respondent number 4, my lord, the executive engineer PWD department, my lord.
He did not forward you the information.
My lord, till date they have not sent.
When did you seek the information?
My lord, since long, my lord, because this matter was in the list, my lord, but
it is there in the list for last
my lord,
1
I'm
year.
only praying for 1 week time, my lord. I'll come with the instruction, my lord. Only 1 week time, my lord.
Please come. The petitioners alleges illegal encroachment of the state highway. ঠিক আছে সেম এটা হবে মুর্শিদাবাদ হাইওয়ে ডিভিশন নাম্বার 2 ঠিক আছে প্রাইভেট রেসপন্ডেন্স এটা হবে by directing the executive engineer Murshidabad highway division number 2 same respondent number 4 same order disposed
Deeply applied.
Deeply applied, my lord.
dismissed.
I appear for the state.
State municipality record appearance dismissed.
578, I appear for the petitioner.
Yes, please.
Now, this relates to non-payment of the dues pertaining to work completed by virtue of tender, my lord.
All right.
My lord, the representation is at page 23 onwards. Love, the completion certificate is also attached, my lord. It will appear at page 21. Parts have been paid, part payment has been made. Remaining outstanding is due. With interest, it comes around 2 lakh odd. My lord, the representation.
But the due is of which year?
My lord, the work was completed in the
Completion certificate page 21. What is the date?
2018.
2018.
My lord. Thereafter, payments were made. Last payment was made in the year 2021.
Please come.
Because
the petitioner seeks payment in respect of successful completion of work. Stop. It is submitted that part payment has been made, but the final bill is yet to be disbursed. Stop. A legal representation on behalf of the petitioner is pending consideration before the respondent authority. Anybody appearing for the state? None appears on behalf of the state. Service taken on record. Stop. In the absence of the any representation from the state, the court is not in a position to decide the issue conclusively. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the block development officer, Shagor Digi, being the respondent number 3 herein, to consider and dispose of the legal representation filed on behalf of the petitioner in accordance with law. After giving reasonable opportunity of hearing to the petitioner for to the representative of the petitioner. Petitioner number 1. To the petitioners. To the petitioners. At the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. If any amount is found due and payable, the same shall be disbursed in favor of the petitioner, subject to compliance of all necessary formalities. Stop. Learned advocate for the petitioner is directed to forward a copy of the pending bills and all other supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
Grateful. Deeply.
Dismissed. Dismissed.
Part 81 for the petitioner, after submitting the writ application, authority has taken steps.
All right. Learned advocate for the petitioner submits upon instruction that the grievance of the petitioners has already been redressed by the authority. Stop. In view of the aforesaid submission, the writ petition stands disposed of.
And I apply for the private response.
Give your appearance, please. Wakalatnama filed? Please check.
In course of this day,
Mr. Das, were you there in 581 or 582?
581. 581.
Are you sure I can see your name in 582? What is the name of your client?
82.
What is the name of your client?
Devnath title.
Pompa Devnath.
Yes.
It's 582.
Extremely sorry. Extremely sorry.
581 is a petitioner there. Record your appearance. Dismiss for default.
Extremely sorry.
This order will go down in 582.
Lordship, in this one, 578, I'm for this state. May I kindly record my name? Lordship, please to dispose of this matter.
But you are not there.
No, I'm just come.
Then why will your name be recorded?
Praying, Lordship.
Why will your name be recorded? The proceedings are live and the petitioner has seen that you are not there. And thereafter, if your name goes in, then the question will be, how can a person who was not there name be recorded?
I just met with the petitioner.
I'm sorry. 582 disposed. ঠিক আছে? 581 টা কিন্তু dismiss for default হলো। এটা Yes. 583 dismissed. Dismissed.
585. Lordship, I am for the petitioner. Mr. Pradeep Mukherjee is leading this matter. He engages in court number 6, Lordship. Kindly make it not today.
What is the matter about? What is the matter?
I'm in the brief today.
You missed the brief. You must be having soft copy with you. Department of Housing. Bengal Shelter Housing. What is it? Accommodation has been sought for by the learned advocate representing the petitioners. List in the combined monthly list of July.
580, I'm for the petition. It is a police inaction matter, my lord. Kindly, my lord, wrongfully filed, my lord. Kindly.
Learned advocate for the petitioner submits that the matter relates to police inaction. Stop. Let the same be released from the list of this bench and be placed before the bench having determination. Record your appearance.
587.
I'm for the petitioner.
Yes, please.
I'm for the petitioner. This is my service.
Yes.
Here, I'm the owner of the plot of land, which I got by filing an application for preemption. Learned court directed that the land to be of the opposite party number is 1 is to be vested to the petitioner. In the front of my petitioner's land, my lord, the opposite party is, my lord, constructing culvert, and culvert has been constructed.
Even the the land belongs to PWD and National Highway Authority. They asked the police to stop the construction, the later highway next, but till then, my lord, now nothing has been done and culvert has been constructed upon just in front of my land, adjacent to this national highway, from Damanaba to Calcutta. And my lord, kindly see the letters. Well, kindly see, they repeatedly asked, my lord, kindly see page 33, the assistant engineer, Kolkata National Highway Subdivision. They are asking the officer in charge to stop this construction. Thereafter, my lord, just kindly see another letter, but nothing.
None appears on behalf of the state respondents despite service. Affidavit of service filed in court is taken on record. List the matter in the combined monthly list of July. Stop. A further notice be served upon the non-appearing respondents intimating the date of hearing. Stop. Learned advocate representing the state shall take positive instruction with regard to the communication made at page 33 of the writ petition. Communication dated 14th June 2024. ठीक है sir?
Matter will appear, my lord,
Combined monthly list.
for hearing.
No. Yes, call the next matter.
We are waiting for the state respondent, Lordship.
State petitioner is not here, dismissed.
Lordship, I am for the petitioner.
Oh, you are there? What is the matter?
The matter is, Lordship, the petitioner is a deceased wife. Lordship, the petitioner wants
Petitioner
is a wife of the deceased husband. Lordship, the petitioner wants there was a order passed by
At page 44, Your Lordship, that representation pending before the SDM.
SDM, Lordship.
Parents, sir.
The 2 or 3 times they are paid younger son. One is a labor, Lordship.
What does your son do?
One son is a labor, one other son is a marine engineer, Lordship. They two times have been paid, Lordship. Till date they are not paying.
Where is the order of the subdivisional officer? The tribunal, is there any order?
It's on letter P1, Lordship.
Page 40, P5.
2017. Interim maintenance, going through statement, OP is payment 10,000 rupees. OP, which OP petitioner is the younger son?
Number 4.
What happened to this application?
Till date,
This is an order of 2017. Thereafter, what happened?
They 2 or 3 times they have been paid, Lordship.
What happened to the proceeding?
Nothing else happened, Lordship.
Show me the orders. From 2017, the matter is pending. Please show me.
Lordship, I don't have the hard copy right now, Lordship. Kindly pass. Kindly pass.
When was the last order passed?
It's on 2017, I think.
Thereafter, what happened?
Nothing was happened, Lordship.
How do you know nothing happened? I can see a date has been given. 30th of August 2017. What happened on 30th August?
There was interim order passed, Lordship, that they have not given the money, Lordship.
Listen, you have made this submission.
Yes,
and the
Lordship.
court has followed it. And the court can also understand that you are not ready in the matter.
Lordship, kindly just pass it over, Lordship. Then I have come back with that.
Take instruction as to what happened to the proceeding which was pending before the subdivisional officer. Because this is an interim order. There must be a final outcome to a proceeding. From 17 till 25, the matter cannot remain pending before the SDO.
I will come back, Lordship.
Take instruction to allow the learned advocate representing the petitioner to come prepared, release the matter on 7th July. Let notice be served upon the non-appearing respondents communicating the next date of hearing.
Lord, only one in. Kindly do not take me amiss. Rushing from court number 11.
Why should you be rushing? Where are the advocate on record and your juniors?
Lord, it's a disgrace on my part. It's a ill luck on my part.
No, ill luck of the court also. What has happened?
I had Item number 587. আর বলতে হবে না, অনেক বলেছিস। I had an item number 587.
Yes.
Now along with it a similar writ petition. They filed a writ petition in which I am the respondent.
No, it's all right, but 587 just now order has been passed.
Well, I was told by Mr. Shondip.
Das, I see.
Yes, yes. He told me that possibly my lords had placed it in the next monthly list.
Please come on that date.
No, I am not. Only thing, my writ petition, which is similar with the matter, that may be tagged.
Where is it?
That is in the list.
Oh, what is the item number?
The item number is 1193 of the monthly list. That is the only indulgence. (1193) of the monthly list. Joyanto Shapui.
জয়ন্ত সাপুই।
Yes.
আচ্ছা, যেখানে ওটা বললাম না? Yes. না না না, সেম অর্ডার হবে না। Let this matter appear along with WPA 3720/2025 within bracket জয়ন্ত সাপুই versus State of West Bengal and others. ঠিক আছে, এই দুটো মামলাকে একসাথে দিয়ে দেবেন। All right.
Kindly do not write tender unqualified applicant.
No, no. The juniors should learn something. You must have been fed up by teaching the juniors by now.
It's a disgrace and it's my ill luck.
Anyway,
it's a disgrace and my ill luck.
Take care of your health. Yes. Dismissed.
I am appearing on behalf of the respondent number 4.
Yes, please record appearance. Dismissed.
Grateful to your lordship.
Did you file your Wakalatnama?
Lordship.
All right. Yes.
My lord, I am appearing for the state respondent.
Date, both of you?
Yes, sir. Yes, ma'am.
Dismissed.
I'm 92. I'm appearing on behalf of the petitioner, madam.
Yes.
In the year 1990, petitioners had purchased certain plots of land from the predecessor of interest of the respondent number 6. Deed of registration, deed of sale in a registered way has been already done. Number of the deed has been already been generated, but later on the concerned ADSR Contai 1 apprehended that forged stamp paper may have been used for the preparation of the registration deed. Criminal case has been started against the stamp vendors. That criminal case still pending. Pursuant to during pendency of the criminal case, in terms of the order of the division bench, the petitioners are agreed to deposit the aggregated deficit stamp duty to get the certified copy of that particular deed. This is the order of the division bench.
Yes.
Representation has already been made, page number 16 P2, and it has been conveyed by the concerned ADSR verbally that until and unless order of a court, you get order of a court, certified copy cannot be granted.
Acha, please come. The representation filed by the filed on behalf of the petitioner before the Additional District Sub Registrar Contai 1, Purbo Mendipur, is pending consideration. Stop paragraph. The petitioner submits that the said representation submits the praise that the said representation may be considered by the authority in the light of the order passed by the Honorable Division Bench in FMA 200 of 2010 with CAN 10275 of 2009. What is the date of this order?
Date of 5th January 2011. I mentioned it on the page 17 in my representation. Notice demanding justice.
একটু চেক করে দেখে নেবেন তো হুম in view of the above none represents the respondents stuff in the absence of any representation from the state the court cannot decide the issue conclusively stuff as it appears that the representation made on behalf of the petitioner is pending consideration at the end of the authority accordingly the instant writ petition is disposed of by directing the additional district sub-registrar Contai 1 to take into consideration the representation filed on behalf of the petitioner in the light of the order passed by the Honorable Division Bench on 5th January 2011 and dispose of the same by passing a reasoned order. Stop. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken by the authority. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Writ petition stands disposed of.
My lord, in this matter, we are appearing for respondent number 2 to 5. This is a group 6 matter, wrongly listed in group 9.
Group 6?
Group 6 matter. This matter relates to disbursement of compensation for death. We are for ECL.
It is mentioned group 9 residuary. Now what to do? The petitioner is also not here. Acha. The petitioner prays for grant of terminal benefits
monthly
due
compensation
to her deceased husband.
Group 9.
Learned advocate representing the Eastern Coalfields Limited and the Union of India submits that the issue ought to be dealt with by the bench taking up service matters. Stop. In view of the above, let this matter be released from the list of this bench and be placed before the bench taking up service matters.
I'm for respondent.
Respondent dismissed. Yes.
Your Lordship,
Yes. You are for the petitioner. I was looking for you. Yes. What is it, Tegi? 594? Yes.
Mr. Arjit Chakravarti is appearing in this matter. He is before courtroom number 238. I'm praying for not today.
Just now you entered appearance. You are also there in the matter?
No, sir, Mr. Arjit Chakravarti is appearing in this matter.
You entered appearance on behalf of somebody else?
No, sir, I'm his junior.
Whose name has gone down?
Mr. Arjit Chakravarti.
He is not present in court?
He is before the courtroom number 230.
Is he present before courtroom number 14? Why will you enter his appearance? You said, I am for the state. There is a difference.
Not a state, for the enforcement directorate.
Whatever. I am appearing and I am holding brief of somebody makes a whole lot of difference. You should learn.
I apologize.
Right? You are not there. Somebody else is there. And on his instruction, you are appearing. Do not give in appearances of anybody who is not present in court. The proceedings are going live. And if the counsel comes and says that I was not present, how could my name be included in the order sheet? What is going to happen? The court will not be in a position to defend. Do not enter appearance of anybody who's not there in court. Yes, what is your prayer?
Well, it takes any day, my lord.
Any other day?
Any other day.
Are you ready?
No, I'm not ready today.
Yes. Accommodation has been sought for by the learned advocate representing the petitioner. List in the combined monthly list of July.
Great.
Yes.
Your Lordship, I am appearing for the petitioner. The instant matter pertaining to non-payment of compensation after acquired of land of the both the minor son of the petitioner by the Indian Railway. In the year 2007,
Under which provision of law?
Railway Act. One second. Please come to page number 21, Your Lordship.
Yes.
Here is the notification. সংশোধিত বিধি 2008 অনুসারে জমি অধিগ্রহণের জন্য দেশপ্রাণ স্টেশন থেকে নন্দীগ্রাম পর্যন্ত রেলওয়ে সংযোগ সংক্রান্ত বিশেষ রেলওয়ে প্রকল্পের ক্ষেত্রে জমি অধিগ্রহণের বিজ্ঞপ্তি।
No, but then amendment act of what is the primary act which has been invoked?
Here it is written, Your Lordship. 7ই সেপ্টেম্বর রেল মন্ত্রক ভারত সরকার বিজ্ঞপ্তি মোতাবেক রেলওয়ে বিধি 1989
Railway বিধি. That means the
Railway Act, Your Lordship.
All right. Yes. You want compensation?
Yes, I have not got compensation by but my name has been published in the notice, Your Lordship.
Please show.
In page number 20, Your Lordship. Dag number 994, Your Lordship. In that dag number, plot number, there are 5 persons. Deepak Kumar Bera, Kalipodo Jana, Sasanko Shekhar Jadhav, Surjokanto Senapati and Chandrakanto Senapati. Surjokanto Senapati and Chandrakanto
Can you
Senapati are
read
the
it?
petitioner.
Because I cannot. My eyesight is not permitting. Can you read?
It's
Is the
not
name
much
there? You also cannot read. Is the name there?
Yes, yes, their
It
name
is there. It is there.
Copy, yes.
All right.
My copy is legible, Your Lordship.
All right. All right. Yes. Non-payment of compensation.
Actually,
When was it acquired?
In the the
2010.
notification was issued in the year 2010, Your Lordship.
Right.
After that, due to several litigation and paucity of fund, the entire project was stalled. In the year 2022, after Honorable High Court order, the project was again started and several person has got compensation and a person, Deepak Kumar Bera, has already got compensation.
Yes.
Lordship, regarding, I have seen in page number 18, Your Lordship, in this read petition. In this read petition, Mr. Deepak Kumar Senapati has submitted an RTI before the railway, and railway has replied the same. And in this RTI letter, the claim of the petitioner has not tenable. In page number 19, Your Lordship.
19
Therefore, the
paragraph
alleged
3.
claim for compensation issue of land, of certificate and land user employment in railway cannot be tenable for the consideration.
Deepak Kumar Bera.
Your Lordship,
1 minute on payment of 26,000 and no apportionment was required from your minor sons. Surjokanto. Who was the owner?
Actually, Your Lordship, the owner is Chandrakanto Senapati and Surjokanto Senapati, but both the sons are minor. As they are minor, they are represented by their father, Deepak Senapati.
So Deepak has got
Your Lordship, that is Deepak Kumar Bera.
Senapati and Bera must be separate.
Yes.
You are Senapati.
Yes, I am Senapati.
Not to transfer the records collected by the estate. Railway, Deepak Kumar Bera
is the recorded owner.
Recorded.
No.
Not Senapati.
Yes. In dag number 994, there are total 5 landowner, Your Lordship.
Listen, if there is some error in the records.
No, there are
then
no
nothing can be
error
done.
in the record, Your Lordship.
Is your name Deepak Kumar Senapati there in the document that you showed? In the chart, is your name there?
Yes, Your Lordship.
Where?
May I show my copy, Your Lordship? Your Lordship, this is
Which page are you referring? 21?
page number 20, Your Lordship.
20. Which portion, please show?
9, 10, 12, 13, 14, 15, 16th box from the left side.
Just raise your brief. Show me the place. Raise it. Which place? Middle. It's Deepak Kumar Bera.
Next name, Your Lordship.
Some Jana, yes.
Shekhar, Senapati Jadov, then Your Lordship. Surjakanta Senapati, Chandrakanta Senapati.
But you are Deepak Kumar Senapati.
Deepak Kumar Senapati is the father of Surjakanta Senapati and Chandrakanta Senapati.
Right.
Both the person are minor. So the name of Surjakanta Senapati and Chandrakanta Senapati is recorded in the BLLR. I have already annexed the porcha, page number 29 and page number 30. As both the sons are minor, the petition has been filed on behalf of them by their father.
The recorded owner's name, compensation is to be paid to be recorded owner. Bera is somebody else. He doesn't want it for Bera. He wants it for Shenapati.
The total land is 66 decimal. Both my petition are on 7 decimal and 7. Total 14 decimal.
The land of the petitioner. The land of the petitioners. No, Tarage Likun, the petitioners are minors and are represented by their father, Deepak Kumar Senapati. Stop. Grievance of the petitioners is that compensation has not been paid in their favor, despite their name being reflected in the notice of acquisition of land. Stop. Next. The learned advocate representing the Union of India is yet to receive instruction in the matter. Stop. It appears from records that the father of the petitioners, Deepak Kumar Senapati, filed an application under the Right to Information Act. And the authority intimated the father of the petitioners that the entire land, 4.37 decimal, was acquired from one Deepak Kumar Bera, son of Bimal Bera, on payment of rupees 26,838. And no apportionment was acquired from the minor sons as per the relevant record of rights. The claim for compensation has not been found to be tenable. Stop paragraph. The petitioners thereafter file a representation through their learned advocate, which is pending consideration till date. Stop paragraph. Learned advocate for the petitioners have annexed to the writ petition copy of the record of rights, wherein the names of the petitioners, Surjakanta Senapati and Chandrakanta Senapati, are recorded. Stop paragraph. Without going into the issue at this stage, as it appears that a representation on behalf of the petitioners is pending consideration at the end of the authority, accordingly, the instant writ petition is disposed of by directing the Deputy Railway Manager, Kharagpur Division, Southeastern Railway, to take a decision on the prayer made on behalf of the petitioner in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties by passing a reasoned order at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. If the claim of the petitioner is found to be proper, comma, then necessary remedial steps shall be taken by the authority without any delay. Step. Learned advocate for the petitioners is directed to forward a copy of the legal representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
Much obliged.
My lord, I'm for the petitioner. My lord, I'm praying for not today, my lord.
Accommodation has been sought for on behalf of the
Lord, I am
petitioner.
number 7.
Please record your appearance. List in the combined monthly list of July. Yes.
597.
Dismissed.
598.
I appear for the state, my lord.
I'm for the petition. I'm praying for not this week.
Accommodation sought for monthly list of July. Record appearance of the respondents.
Lord, I'm grateful. 599.
I'm for the state.
Dismissed. Record appearance, please.
600.
Dismissed.
601.
Lordship, I'm appearing on behalf of respondent number 2 and 3.
Give your appearance. Dismissed.
602.
This matter, I am for the state.
Yes, what is the matter?
My lord, petitioner was an employee of a cooperative society. My lord, petitioner was terminated from his service in the year 2014. My lord, after that applied for the release of the provident fund benefits, but my lord, till this date, no amount has been released.
Isn't it? Will it not be a service matter?
No, my lord, service
Why?
has been terminated, my lord.
Yes, but then it relates to Group 6 service, isn't it?
Is it withdrawal of provident fund, my lord?
Then it will be Group 3?
Yes.
Very well. The matter relates to withdrawal of provident fund. Stop. Let the same be released from the list of this bench and be placed before the bench having determination. Yes, next. Dismissed. Dismissed.
605.
Yes. What is the matter?
Yes, ma'am. Yeah, TP number, they have served some copy. I don't miss certain page. If your lordship can.
What is the matter?
Yes, ma'am. One Ashok Mari got the property by way of gift in 1990. After his demise, the property devolved upon his 3 legal heirs, petitioner number 1, 2, and 3. For the purpose of development, that particular property, petitioner number 1, 2, and 3 entered into a development agreement with the petitioner number 2. Meanwhile, petitioner number 2 is an employee of a post office. There was an allegation of defalcation of money, a criminal case started against petitioner number 2.
What is your prayer?
Yes, madam. For the purpose of investigation, if your lordship kindly turns to last page of the writ petition.
What is your prayer, please say?
For taking aside of the annexure P9 that appears at page 108, but I was suspended, petitioner number 2 was suspended and he has been reinstated. Now he is in service. This is a communication from the district register to the IGR. May I be permitted to hand over the type copy?
You are here very good to provide information purchasing. Yes.
Well, this is a communication from the district registration office, South 24 Parganas, to the Inspector General Then in reference to the above, your lordship kindly consider type copy of.
Yes, reread.
Yes,
I forward here with a copy of the
Whether
letter of
the
the
question
ADM
is
for stop of sale of properties held by Pradeep Marik.
Pradeep Marik, the petitioner number 2 and his family members. But if your lordship kindly turns to the previous page, wherein the officer in charge, the investigating officer intimated to the.
This property is involved in a criminal case.
No, this is no way involved in the criminal case. This is a property which I have inherited from my father.
Yes.
Now the district register had intimated to the inspector general not to alienate that property.
Yes.
Not even still I am in service. I have been reinstated. Even if there is any pecuniary loss, my lord, that can be realized from the service benefit of the petitioner.
No, how are you aggrieved? What do you want to do with the property
I
now?
am not in a position to deal with the property.
What do you want to do? You want to sell it off?
Because that has been, there is a development agreement between the petitioner number 1 to 3 and 4.
Yes.
Because unless that can be alienated to the intending purchaser.
You obtain order from the trial court where the matter is pending.
Kindly appreciate the page 107 under what necessitated the district register to intimate, because this is not a part of the criminal proceeding.
Any instruction do you have?
Today at 2 p.m. that I have stated.
Today at 2 p.m. you received the brief. Brief was served earlier.
Certain page was missing. Yes, my lord.
Please come. The petitioner prays for setting aside page 108 of the writ petition. Stop. Learned advocate representing the state respondent shall obtain instruction released in the combined monthly list of July. Affidavit of service filed in court is taken on record. এই পাতাটা page 108. Yes.
Respond number 7.
Petitioner participate in a selection process. Thereafter, in connection with that selection process, the petitioner made RTI application. That is not disposed of till date.
When was the selection
held? This is 2016 selection process for classes 11, 12 and 11 and 12.
Yes. Then
the petitioner made certain queries before the SPIO of the commission.
When
the petitioner made
page 15, madam.
Page 15.
Right.
On first 25th January 2023.
Why in connection with 2016 you come up in 23? For what good reason?
The selection process was challenged, and that is there is the selection process is also set aside. Now
then why do you want information?
Now the question is the tainted, untainted, the petitioner in
there is the authority has not been able to segregate the tainted and the untainted. Then what information will they provide?
I in respect of mine, my lord, I have certain queries, my lord.
Yes.
And that is, kindly come to page number 22.
Assuming page 17, you made the application under the Right to Information Act. Thereafter, the first appellate authority, did you go?
Yes, my lord. Page 22. My lord, the
Page
second
22.
appellate authority, that is pending, my lord.
Second appellate authority is pending?
Yes, your lordship. My lord, this petitioner made online application, my lord. His application diary number is there, my lord. First one, my lord, 05, my lord, 6 405. That is that is made on 21st November 2023, and that is pending, my lord, till date.
Online application.
Yes, second appellate authority.
I am for the second appellate authority. I need to instruction, lordship, the second appeal are pending or not, lordship, because of many appeal are disposed of, but till date I don't know. Kindly have.
The second appeal filed by the petitioner?
Tomorrow or day after tomorrow, lordship.
Before the? Made by the petitioner under the Right to Information Act, 2005, is pending consideration. Stuff. Learned advocate for the authority seeks time to take instruction. Stop list in the combined monthly list of July. Instruction shall be obtained in the meantime. Service is taken on record.
I'm a petitioner, my lord. My petitioner, my lord, take a retired from service, my lord, from the
Yes.
my lord, retired from UK Bank in the year 2021. My lord, in course of the retirement, my lord, from the retirement benefit, excess amount was deducted. My lord,
Why are you here? It will go before the service bench.
no, my lord, no, my lord, that received my lord after retirement, my lord, retirement benefit, my lord, the
Retirement
excess
benefit is connection with the service. It will go before the service bench.
my lord, loan, my lord, excess amount was in connection with the loan amount. My lord,
Connection with the loan.
my lord, in course of the service, my lord, tenure of the service, he took the loan.
All right.
And loan was repay.
Hmm.
And in the at the time of retirement, my lord, again, my lord, same amount was recovered from the post retirement benefits. This the repeatedly asked the authority concerned kindly refund. Authority concerned not taking the step, my lord.
Where is the representation?
Kindly, my lord, page 31. My lord, the last representation page 31.
Pay for refund of excess amount. Please come.
Earlier 30.
None represents the bank. Top the petitioner's prayer seeking refund of excess amount allegedly recovered from him on account of payment of the loan is pending consideration at the end of the authority. Stop. In the absence of any representation from the bank, comma, the court is not in a position to decide the issue conclusively. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the
Respond number 2, my lord.
which bank?
My lord, UCO Bank, my lord.
Which? Where is the branch?
My lord, registered branch, my lord, 2, my lord, respond number 2, my lord.
Why will the respondent number 2 decide? Where from did you obtain the loan?
Loan. My lord, retired from Salt Lake branch.
Took loan from which branch?
My lord, Tejpur, my lord, Tejpur, the Assam. At the time of the posting the Assam. Thereafter, my lord, Bharti of retirement, say come to the transfer to the home stay Salt Lake. And from the Salt Lake, he retired.
Salt Lake he retired. Yeah. And who is deducting the loan amount?
Loan amount, my lord, from the Tejpur.
That means the cause of action arose somewhere else.
No, my lord, transfer the account from the respondent number 2 managing director, the chief, my lord, the authority. All the after transfer, my lord, all the record will come to the head office.
Which transfer?
My lord, the official rotational transfer. At the time of the loan amount, they took the loan from Tejpur. And thereafter, my lord, due to an official transfer, they transferred the Salt Lake branch. And then from the Salt Lake, he retired. And
he have retired from Salt Lake. Who is deducting the amount?
My lord, the amount that deducting from the Salt Lake branch, the senior manager respond number 6.
Respondent number 6 के direction दें तो. Directing the respondent number 6. The senior manager, UCO Bank. এই পুরো ঠিকানাটা লিখে দেবেন। To take into consideration the petitioner's representation in accordance with law and dispose of the same at the earliest, but positively within a period of 6 weeks from the date of communication of this order. Step. If the claim of the petitioner is found to be proper, then necessary remedial steps shall be taken by the authority. Disposed. তার আগে learned advocate for the petitioner is directed to forward a copy of the representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Yes.
Good.
But 608 is my application.
Yes.
It pertains to a insurance policy fraud. But the petitioners have taken various insurance policies. The sum assured amount 3. There was a certain assured amount. The agent, the insurance agent, used the LIC policies. Created changed the KYC, created a separate bank account, took loans from that bank account, and the debits are being made from this money is arising out of the LIC policies, which belongs to the petitioner. We had written several letters. FIR was lodged. Investigation is ongoing.
Where is the default on the part of LIC?
It is the agent of the LIC. What we are requesting the LIC to do is to change the KYC, change it in our favor, and not to further debit the amounts from our policies.
No, but then will the LIC be responsible for this?
No, we are not.
Show me your service, please.
Activity service.
None represents the Life Insurance Corporation. Stop. Affidavit of service filed in court is taken on record. Stop. Let a further notice be served on the non-appearing respondents, intimating that the matter will appear in the list, appear in the combined monthly list of July. Stop. Necessary instruction shall be obtained by the learned advocate representing the Life Insurance Corporation. In the meantime, come back.
Great.
Dismissed.
My lord, I appear for the respondent numbers 2 to 5, my lord.
Yes.
My lord, our primary grievance is that, my lord, within the new town Kolkata development area, NKDA area, my lord, town vending committee has been constituted, my lord, which according to us, my lord, is not in accordance with the law. My lord, the law requires something and they have done something else. My lord, they have evicted hawkers, my lord, without the due process of law, as has been, my lord, enumerated in the Street Vendors Act. My lord, we have made representation, your lordship will find in part 2 of the, my lord, the petition.
Page?
My lord, page 39 onwards, my lord. 39 onwards. And the, my lord, detailed representation is at page 53. 43. 53 is the same, my lord. 40. What a mass petition. My lord, page 43 is a more detailed, my lord, representation.
Hawker Sangram Committee of Kolkata 12 is writing to NKDA.
My lord, because the town vending committee, my lord, as required under the law, my lord,
Yes.
they will have to have, my lord, representative of hawkers. My lord, this Hawker Sangram committee, my lord, they were part of a digital survey which was being conducted by NKDA along with police in 2020. My lord, it was about 85% complete, that survey. Suddenly, abruptly, my lord, that survey was, my lord, stopped. Thereafter, nothing happened. My lord, the act requires, my lord, if your lordship may kindly
Let me hear NKDA. Do you have any instruction?
My lord, I will take instructions, my lord. What I have, my lord, may I kindly seek, my lord, an indulgence to file an affidavit in opposition to the writ petition?
Please come. The petitioner's representation. Alleging certain infraction of the provisions of the Street Vendors (bracket open) Protection of Livelihood and Regulation of Street Vending (bracket close) Act 2014 is pending consideration before the chairman, Newtown Kolkata Development Authority. Step. Without entering into the merit of the claim of the petitioner, comma, the instant writ petition is disposed of by directing the chairman, Newtown Development, Newtown Kolkata Development Authority being the respondent number 3 herein, to consider and dispose of the petitioner's representation strictly in accordance with law after giving reasonable opportunity of hearing to all the necessary parties by passing a reasoned order at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. If the grievance of the petitioner is found to be proper, comma, the necessary remedial steps shall be taken by the authority. Step. Learned advocate for the petitioner is directed to forward a copy of the subject representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court.
Deeply obliged, my lord.
Keep report of the Newtown police station dated such and such be written with the records.
Deeply obliged, my lord.
Grateful. 111, my lord, I am for the petition.
My lord, I am appearing from Damodar Valley Corporation.
My lord, the matter, petitioner before your lordship is a government contractor who got the tender being the L1. Thereafter, the authority did not provide it the rake which was indicated in the job. They given notice to the bank to realize the bank guarantee. I have filed this writ petition challenging the invocation of bank guarantee. Thereafter, they have blacklisted, debarred from the tender participation. We came before your lordship and filed another application, writ petition, where your lordship was pleased to give interim order and thereafter exchange the affidavit and opposition and reply which is pending. So my lord, my prayer is this main matter is pending. So this matter maybe go out
You
of
want
list.
this
My lord,
go out of list or you want to be tagged?
Lord,
What
we
is
want
the
to
prayer in the
we want to use an affidavit in opposition here because Lord, they have challenged basically the termination order. Lord, the debarment order has been challenged in the next writ petition. Lord, where
here it is the termination.
yes, Lord,
Here it is the termination. To reinstate the petitioner to complete the work by revoking the order of termination. But then has the work been completed?
Milord, they didn't complete the work. That is why debarment and all this happened. And invocation of bank guarantee. Now they in the
work because of my lord
in the
kindly
subsequent
come
writ
to
petition,
page
Lordship was
34, page 3, where they have provided
1 minute.
only
Now
few
the
recs.
termination is there.
Yes, my lord.
And then debarment is also there.
My lord.
Anyway, please come. The petitioner is aggrieved by the order of termination passed by the Damodar Valley Corporation. Stop paragraph. It appears that the order of debarment issued by the authority is also under challenge in a separate writ petition filed by the petitioner, where direction for exchange of affidavits had been passed. Stop paragraph. Learned advocate representing the corporation seeks time to file affidavit in this matter also. Paragraph. Let affidavit in opposition be filed by the respondents within a period of
6 weeks.
6 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing after completion of affidavits.
Grateful.
Grateful.
Dismissed.
My lord, I am appearing for the petitioner. And I am led by Mr. Sagar Bandyopadhyay in this matter. Lord, the issues in the writ petition will require affidavits to be exchanged.
Similar order passed by Lordship. This requires
filing of affidavit, my lord. Other writ petitions are also pending.
Yes, my lord.
So, my lord, give us, my lord, 6 weeks time, my lord, we'll file everything.
What is the issue?
My lord, issue is, lordship, will come to page
No, just tell me, don't pages. Just show me pages. Tell me what is
Sir,
the
a
issue.
scheme was introduced. A
Scheme.
Yes, a scheme was introduced.
That is under challenge.
Yes.
All right.
Conferring some benefits.
For?
Well, initially, a scheme was there for the conferring some benefits. Subsequently, the scheme was, my lord, withdrawn.
Yes.
Subsidy or something. Subsidy scheme.
Yes.
Acha, Ashu. Same order.
My lord, there are
8 weeks, 2 weeks.
my lord, there are 4 matters. My lord. The next matter.
Please wait, one by one. 614, same you are appearing? Same appearances and same order.
Yeah.
Where are the other two?
The other 2 matters are at item 1899 and 1900.
Oh, I don't know.
You are not appearing.
1899.
If one matter is disposed, the others can follow.
Yes, your lordship.
Yes. 15615.
Yes.
I'm for the petition.
Your ladyship, I beg to appear for the Central Food Safety Authority, my lord.
Well, this
For the state respondent.
well, the main allegation is that the private respondent is running a business which is hampering the petitioner's life and health of the and also the society.
Petitioner's life
and health, because they are using the running the business without license of and also the certificate of enlistment or trade license, and also the fire license is not there, and which is disturbing the
What is the business that is being run?
well, the business is mainly it is now running in the name of Joya Caterers, but it is actually making food and for the peoples.
Manufacturing food items over there.
For yes.
Is there any open flame or fire over there?
Yes. And for that, the life and health is being hampered. For which is the petitioners has also made the representation, which is page 60.
State?
No,
Do you have any instruction from the fire authority?
No, police has given.
No, police. Let me see what the police has got to say. You are for?
My lord, the Central Food Safety Authority. We have already issued a letter to the petitioner saying that this particular jurisdiction does not fall under the Central Authority, my lord.
What about the West Bengal Pollution Control Board? Did you serve?
Yes, your lordship, I have served. But this is the private respondent which has returned.
No.
Insufficient address.
But it is told that item served, item intimation served.
Intimation, sir, will not do this. Please come. Yes, please. What does the KMC say?
But business is non-functional, but the prayer that has been laid down here is absolutely civil in nature. The prayer that has been sought is not to interfere to his premises, and other prayers are also there. And if the allegation is against the KMC, your lordship, then this will come under Group 5 determination. And apart from this, your lordship, we have taken the instruction, the business is non-functional, at least when the inspection was commenced.
The petitioner alleges illegal running of business by the private respondent without obtaining proper permission/license from the fire and emergency services and the Pollution Control Board. Stop. Paragraph, the petitioner alleges that the private respondent is manufacturing food items from the subject premises, which is causing a threat to the healthy life of the petitioner. Stop. Next. None represents the Pollution Control Board. Stop. Learned advocate representing the corporation relies upon the instruction forwarded by the food safety officer of the corporation. Borough 8, dated 30th July 2024.
Lordship, we have refrained the petitioner from proceeding with the food business activity.
Wherefrom it appears that the subject unit was found non-functional on the day of the inspection on 10th July 2024. The private respondent was present at the premises but could not submit any FSSAI registration certificate / license in support of the business. Stop. A refrain notice was issued to the private respondent. On 10th July 2024. Further inspections were carried out on 15th July and 19th July 24, but the business was found non-functional. Stop. What is your submission with regard to the non-functioning of the business?
But that I have no instruction.
Acha. As it appears that the corporation has already taken steps in the matter and has issued a refrain notice to the petitioner, to the private respondent. Let the private respondent not operate the business till proper licenses from all authorities are obtained. Stop. The officer in charge, Ravindra Sarovar Police Station, is directed to keep strict vigil in the area so that the private respondent does not commence the business without commence the business contrary to the provisions of law. Writ petition stands disposed of. You please pass on this information to your learned friend so that he can follow it up next time.
Can forward this instruction to him?
Yes, please do. And after finish, the report forwarded by the officer in charge, Ravindra Sarovar Police Station, signed on 8th August 2024, be written with the records. Affidavit of service filed in court is also written with the records. Learned, the unserved writ petition sought to be served upon the addressed to the private respondent is opened from the envelope and returned to the learned advocate on record of the petitioner. Stop. The envelope, however, will remain with the records. Take back the writ petition.
Lordship, the report that has been forwarded may be kindly also be recorded if your lordship.
Copy of the report of the food safety officer of the corporation has been handed over to the learned advocate for the petitioner.
Grateful.
Grateful.
Dismiss. Yes, dismissed. 10 appear করেছে।
618, I am appearing for the petitioner, my lord.
Yes, please.
My lord, the grievance of the petitioner has been meted out, my lord. This
Very well.
petition.
Learned advocate for the petitioner submits that the grievance of the petitioner has already been redressed.
I am for the respondent.
Perfect.
My lord, I am for the respondent. Perhaps this matter should go to my lord, courtroom number 17.
The petitioner does not have any issue.
কি withdraw করছো?
In view of such submission,
Oh.
the writ petition stands disposed of.
Lordship, I am grateful.
Much of this.
Please record appearances.
My lord.
Lordship.
I'm respondent number. I'm respondent for Union of India. Union of India is the first. I'm respondent number 1, 4, 5, 6, 7, and 8.
Give your appearance. Dismissed. Where is the application? Jana Babu.
Parties of the FCI from Delhi to Calcutta, they are not necessary party. That's
Alright.
why I have filed an application.
As the writ petition has been dismissed for default, no further order is required to be passed in the connecting application. Stop, the same stands disposed of. Dismissed. 620. Please enter your appearance.
আপনি এটা আমি আছি FCI না আপনি
621 my lord, I am for the petitioner. দেখি একটু। The petitioner had died on 16th June, my lord. Necessary application has to be filed, my lord.
Learned advocate for the petitioner submits upon instruction that the petitioner expired on 16th June 2025. Stop. The learned advocate seeks time to take further necessary steps in the matter. Stop. In view of such submission, let the writ petition be delisted for the time being. Yes, next.
My lord, only thing, my lord, to liberty to mention, my lord. If the
File application.
all right.
So liberty is always there. You have to take steps for substitution, isn't it?
Yes.
Take steps.
My lord, item 620, we just got stuck in the behind. Item number 620.
It
It
has
was
been
just called.
Yes.
I am appearing for the petitioner in that matter.
620.
620.
There were many for the respondents.
I am appearing for the petitioner.
Many were there for the respondents. Get hold of them.
I appear for respondent number 2 in that matter.
Yes, somebody else also appeared, isn't it?
Recollect, my lord. Because state is another respondent. My respondent number 1 is state.
Yes. Who is the answering respondent?
Madam, we are the answering respondent.
2 means who?
West Bengal Industrial Infrastructure Development Corporation.
All right. দেখি 600 কোটিটা একটু দেখি 620 let me see. দেখুন তো স্লিপ গুলো দিয়েছে 600 কোটি থেকে ছিল 600 কোটি স্লিপ দিয়েছে এক্ষুনি What is the matter?
না না 2025 ক্রেডিট আছে
What is the matter?
My lord, it was challenging the order of cancellation of lease deed.
Yes. Where is the order?
Page number 67 onwards.
Yes. This is not the notice of cancellation. This is an operationalization
Well,
of
this is
the
resumption notice. Well, this is resumption notice. But notice of termination is of, because kindly sees the notice of terminations
February
has been referred.
2023.
It is of 7th February 2023.
Yes.
My lord, the termination is at page 61, my lord.
Let him say what he's got to say. Are you ready or not?
But, I am seeking for an adjournment.
Seeking for an adjournment. Adjournment sought for by the learned advocate for the petitioner. Stop. List in the common monthly list of July.
I beg to appear on behalf of the petitioner. With the petitioner before your lordship is the
Who is for the state?
I have served.
You served. What is it?
Kindly come to page 11.
Yes.
Under the scheme of destitute Muslim women for benefit of my lord, this the housing benefit for construction of their house. They made an application before before the authority concerned. The authority concerned did not take any steps. So only my lord, I am seeking a direction upon the the additional district magistrate to cause an inquiry. If it is the petitioner is eligible, found.
No, cause an inquiry under which provision of law?
The destitute Muslim women rehabilitation program.
Show me.
My lord, this the judgment which has been, my lord, this similar order which has been passed by my lord Justice Sampal Sarkar, page 12. My lord, the second para. So now,
whether this program is still on or not,
my lord,
nobody knows. This is the
order,
2022 order. We are in
if
25.
the scheme is not, my lord, I can before your lordship. If the scheme is not available, my lord, I am not eligible. If the scheme is available, my lord, I am not seeking. My lord, scheme is exist. Last month, my lord, somebody else got, my lord, so far my instruction is this, my lord, somebody else, my lord, got the benefit.
Please come. None appears for the state respondents. Stop. Affidavit of service filed in court is taken on record. Stop. The petitioner's representation before the block development officer.
My lord, the block development officer,
For
not my lord, this is a kindly additional.
Grant of benefit under the Destitute Minority Women's Rehabilitation Program is pending consideration. Stop. Without going into the merit of the claim of the petitioner, the instant writ petition is disposed of by directing the block development officer.
No, my lord, respondent 5. My lord, this is I know, my lord, this is what will my lord he do.
ADM.
Is
Why?
that according to scheme, my lord, ADM is.
You are not being able to show the scheme.
My lord, this
And now you say it is the scheme.
On me, my lord, I move this.
In the earlier writ petition, order was passed upon the video.
Video because of that after eligibility.
Then show me something.
My lord, this then
the eligibility will not be considered by the ADM. It will be considered
ADM
by the
will forward because of the at the supervision of the ADM. Then my lord, everything will come by my lord, the reveal. My lord, DM, my lord, video will not because of the local. I will not, my lord, say something, my lords. My lord, this influence is there, my lords. My lord, this ADM, my lord, I seeking with ADM. Or authorized persons of the ADM. Under the scheme, my lords, I
petitioner shall approach the BDO for redressal of the grievances. No, sorry, BDO. Block development officer.
I say again,
Mathurapur 1.
It will be
to take
rejected.
into consideration the prayer of the petitioner in
After
accordance
inquiry, my lord?
with the subject scheme.
Lordships. And after my lord, inquiry.
After causing an inquiry.
And advance notice, my lords.
Causing an inquiry with prior notice.
To lordships. I mean, it is found, my lord.
Yeah, just if the petitioner is found eligible
Lordships.
in terms of the scheme, then necessary consequential relief shall be provided to the petitioner. Steps shall be taken by the aforesaid respondent at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Petition disposed.
How
All the next matter.
Request of apology, may I, my lord, mention item number 583, lordship.
Allow me to state the brief facts. My lord,
You tell me what your prayer is.
Yes, my lord. My prayer is, my lord, as per
SLSA.
As per section 85, 86 and 87,
yes,
state government, they had to form an advisory committee for those persons who are coming out of the correctional home after being acquitted. This petitioner was in the custody. She's a lady, my lord, in 13 years. After 13 years, she was acquitted from this honorable court. Now, my lord, she is practically, my lord, begging, starving, my lord. She has no job, though she used to work a job, my lord. As she was arrested, her work that has gone away. Now, my lord, kindly sees, though there is a specific provision, my lord, in section 85 and 86 for rehabilitation assistance, financial assistance for such kind of persons, my lord, whether this advisory committee has been formed and whether any policy has been prepared.
It will be answered by the state, isn't it?
Yes, my lord. Yes,
Please
my
come.
lord. Yes.
None represents the states. Let me see your service. Service.
Relief claim against the SLSA lordship. So my humble prayer, let SLSA may be expunged from the cost title.
No, my lord.
Remain here. Why you do not have any difficulty.
Also, we do not know who are the members of the
None,
advisory committee.
none for the state Bullam. Affidavit of service is filed in court is taken on record. Stop. Let further intimation be served upon the learned advocate representing the state respondents that the matter will appear in the combined monthly list of July. Stop. Necessary instruction with regard to the representation filed
page 24
by
onwards.
the petitioner.
Page 24
Annexed at
onwards.
page
Yes,
is
madam.
24 onwards in the writ petition shall be obtained in the meantime.
Grateful, my lord. Grateful.
Yes, call the next one.
My lord, may I have your lordship, my lord, kindly, my lord, to mention item
686. I'm praying for not today, my lord.
Which one?
686.
686. It's a long way to go. We are in 624.
Or my lord, my juniors are there. They will pray for some time, my lord.
Whatever. Now it is 624.
Grateful.
My lord, am I audible, my lord?
Twist.
For the petitioner, I have served the copy to the other side. So this is the affidavit service. Petitioner lordship come to the lordship. So petitioner come to your lordship with a very limited prayer. That your lordship, petitioner is the your lordship the participant in the bidding process conducted by the your lordship IOCL. He participated your lordship in the bidding process. Thereafter, your lordship, the bidding process was granted in favor of the respondent number, private respondent here in your lordship. Who your lordship, the petitioner alleged that the false certificate has been submitted by the your lordship, the private respondent herein, and obtained the your lordship, the dealership. Petitioner made representation to the concerned authority, your lordship, the issuing authority, who is the your lordship, the issuing authority to the your lordship, the caste certificate. Despite your lordship repeated representation, that was not considered. So that
Tell
will
me one
happy, your
thing.
lordship.
Is it for the authority to ascertain, verify the caste certificate that has been issued? Is it for the authority? The authority is not the competent person to ascertain the genuinity of the certificate. What will the authority do?
Your lordship, since your lordship that the issuing authority is the SDO, and they have submitted your
Where is your communication before the SDO?
Yes, so kindly come to the page number 25, your lordship.
Yes.
And I made a RTA application your lordship to the SDO.
Yes.
I thereby your lordship sought some information regarding the your lordship, the issuance and validity of the certificate. They replied, your lordship, the SDO replied, your lordship, that the documents is not found there in the your lordship, the text. So that is your lordship raised some serious concern.
Not correct, my lord.
So kindly your lordship come to the your lordship.
Who is for the state?
I have
on behalf of the oil company.
That I
This is the your lordship, the documents.
SDO has confirmed, my lord. We have written to them, my lord.
SDO has confirmed.
My lord.
Please show me that the
Yes, my lord,
confirmation.
this is the letter, my lord. On the basis of the complaint of the petitioner, my lord, an investigation was carried out. SDO was written, and he has confirmed that the certificate is genuine one. Like the next page, next page is the certificate of the
And my lord, kindly see this is
1 minute. Nikhil Kumar Mondal.
আপনাকে দেয়া হয়েছে ছুটিটা। Was our order on the basis of the next page.
and my lord, this one kindly see, my lord.
Keep it. This court is also not the authority to decide. Please come. The
Last
petitioner,
page is the certificate, my lord. Next page, my lord.
2001
the
certificate was
petitioner
2005.
So petitioner will, your lordship will be happy
uh,
with your lordship to
is
consider.
the petitioner alleges that the caste reservation certificate relied upon by the private respondent for obtaining, not obtaining, for participating in a bidding process at the instance of the Indian Oil Corporation Limited is a fake one. Stop. A complaint by the petitioner was lodged before the subdivisional officer. Stop. The instant writ petition has been filed alleging inaction on the part of the subdivisional officer to dispose of the complaint of the petitioner. Stop. None appears on behalf of the state respondents despite service. Stop. Affidavit of service filed in court is taken on record. Stop. Learned advocate representing the Indian Oil Corporation Limited relies upon the communication made by the subdivisional officer, Jangipur, Murshidabad, wherefrom it appears that the certificate relied upon by the private respondent has been found to be in order. Stop. Next, the allegation of the petitioner regarding fake certificate by the private respondent could not be substantiated. Stop. Next, learned advocate representing the private respondent produces a copy of the caste certificate.
Caste certificate, my lord, first page, my lord, and this is the certificate again issued by the.
Very well.
My lord.
Stop.
First,
Next,
letter.
the above, the
And LOI was issued.
the
in favor
grievance of the
respondent.
petitioner does not appear to be proper. Stop. The writ petition fails and is hereby
Your
dismissed.
lordship, kindly, your lordship, since
Next.
your lordship, the grievance of the petitioner is that, your lordship, that the private respondent submitted, your lordship, some false documents. And the legality of the certificate, I'm not, I have not also mentioned there in the petition, your lordship, that the certificate was issued, not issued by the, your lordship, SDO. My grievance is that, your lordship, that the certificate issued by the SDO, but the private respondent submitted some false documents. And your lordship, the false, your lordship, the
626.
legal certificate. Kindly, your lordship, since your lordship,
The private issue, tell it.
626. Right. Dismissed. My lord. 627.
26. I'm for the 26. I'm for the 26.
626. You are for the?
Appellant, my lordship.
You are for the
Petitioner.
petitioner? Yes. What is the matter?
My lordship, the advertisement record is out of state. Kindly make it not today.
626. Accommodation sought for on behalf of the learned advocate for the petitioner. Combined monthly list of July. 627. Dismissed.
I like to have for the petitioner.
Yes.
Oh, sorry.
Oh, 28, I'm for the petition. I'm for the petition, man. Well, if it is service has not been confirmed, man, service is completed, man, but affirmation has been completed, man.
All right. Show me the service at least. You have document?
No,
Where is the letter? Letter is also not here.
No, Malak, but only today, not today, Malak. I have. Yes. No.
What is your prayer?
I have. Well, pair, Malak, authority has rejected this my pair. Malak page. No.
Authority has rejected your prayer?
Yes, Malak. I have Malak page 14. 14, Malak. Annex P2. 14 page annex P2.
2017.
Yes, Malak. Malak settlement of pending such as a complaint registered with reference to the CPGRM complaint is to intimate that on inquiry it is found that opening of new post office at Sasapota village does not justify as per the department norms. Hence the case is settled, manner. On the basis of this letter, manner, I have given the representation, manner, page 30. Page 30.
Yes.
But till date, he has not considered this.
What you want? Setting up of a post office?
Yes, yes.
Which place?
Which place? It হচ্ছে ব্লক লেভেল হচ্ছে খানাকুল।
Sasapota village?
Yes, yes. খানাকুল, Subsidy.
Please come. The petitioner prays for setting up of a post office.
Yes, ma'am.
Within the Khanakul block, Khanakul 2 block.
2 block, development.
Under the MAROKHANA. Page 19, একটু দেখবেন তো। Gram Panchayat stuff. The prayer of the petitioner stood rejected by the Superintendent of Post Offices, North Hooghly Division, Chinsura. Stop. The petitioner has appealed against the same before the. It has been rejected. You have again filed.
আমি reconsider. I have application filed for reconsider.
আচ্ছা কি বললাম? The petitioner has prayed for. No, the petitioner prays for reconsideration of the prayer. Stop. Would you like to file a fresh representation?
Yes,
Because from
yes,
18
yes,
to
but yes,
25.
grateful, man.
ঠিক আছে? On a reconsideration of the prayer paragraph, I have perused the documents annexed to the writ petition. Stop. It appears that a proper representation ought to be filed by the petitioner before the competent authority. Stop. The representation which is annexed to the writ petition is a very sketchy one, bereft of the material details. Stuff. Next. In view of the above, the instant writ petition is disposed of by observing that it will be open for the petitioner to file a proper representation highlighting his grievances. Stuff. In the event such a representation is filed, the same shall be considered by the authority in accordance with the prevailing rules at the earliest. Disposed.
Grateful.
The letter dated 8th August 2024 of the learned advocate on record, addressed to the respondent authorities, be written with the records.
Only pair mala. Time limit.
There is no representation as on date.
Grateful, man.
Dismissed. 629, yes.
I have served, man. Name of the petitioner is my lord.
What is it?
The petitioner is praying for clearing his bills for supplying raw materials for implementation of the project under MGNRGS. These bills are pending before the authority since 2022. But some of the bills, total 129 bills, I have submitted out
What
of that.
work do you perform?
But for supplying of raw materials for construction of poultry farms. But kindly see.
Where is the work order?
Kindly see first one, page 18, 1A.
Yes.
But the direction was given upon the block development officer. But as per direction, this is to inform you that total numbers of schemes, construction of cattle shelter with pakka floor, one number of bitter vine cultivation and 125.
Yes, it's all right. Where is the work order in your favor?
Work order is that, my lord, at page 23 onwards.
23 onwards.
23 to 27.
Prithu Enterprise.
I'm the sole proprietor of Prithu Enterprise. I have stated in my writ petition.
All right.
And the bills, my lord, I have submitted, my lord, from 29 onwards.
Who is this Sri Aurobindo?
Sri Aurobindo SKU. It is the implementing agency. If you also kindly have a look at the tender notice. It is at page 20. Well, this is issued by the Cooperation Directorate.
Yes.
Sri Aurobindo SKUS Limited, name of work so-and-so for procurement material under MGNRJ for Sri Aurobindo SKUS South 20 Pargana.
So you do not have any privity of contract with the state authority. It is the SKU who was given the work.
Next paragraph, if you also kindly have a look. Sealed tender is prescribed from issued in the office of so-and-so is hereby invited from bona fide suppliers, contractors for purchase of material annually as mentioned in Annexure 1. So, this Sri Aurobindo is the implementing agency appointed by the state government.
Now the implementing agency has not come. Whatever grievance
I have made that.
Whatever grievance you have will be against Aurobindo, not against the state.
One thing, my lord, kindly see, my lord, one document I will show, page 32.
Yes.
But the practice is that, my lord, I submit the bill to
whatever the practice is, there is
Sri
no.
Aurobindo has submitted it to the authority concerned. Kindly
Yes.
see page 32.
Yes.
It is written by the assistant.
But then Aurobindo has not come. Please come.
Aurobindo, I have made party as respondent number 6.
Nothing doing.
Kindly
The
consider.
petitioner seeks
Kindly
payment of certain bills. Stop. It appears from the documents annexed to the writ petition that the Cooperation Directorate of the state floated a tender pursuant to which one Sri Aurobindo SKUS Limited engaged the petitioner for performing the work. Stop. The bills of the petitioner are yet to be cleared. Stop. Paragraph. It appears that the tender implementing authority, that is Sri Aurobindo SKUS Limited, has not approached the authority with the allegation of non-payment of bills. Stop. The petitioner does not have any privity of contract with the Cooperation Directorate of the state. Stop. At best, the petitioner may have a grievance against the said Sri Aurobindo SKUS Limited. Stop. Paragraph. The implementing authority cannot be treated as state under Article 12 of the Constitution of India, and accordingly, writ petition at the instance of the petitioner. The writ petition at the instance of the petitioner seeking direction upon the authority for clearing the bills cannot be accepted by the court. Stop. The writ petition accordingly fails and is hereby dismissed. Stop. Dismissal of the writ petition, however, will not stand in the way of the petitioner to take steps against the implementing authority for a recovery of the due amount.
But I pay for the register lordship 234.
Very well.
But the agency has submitted bills to the authority concerned, it was approved. But payment has not been made by the state respondent. That is the reason why the implementing agency is not. Page 32 and 33.
You are representing 4 also.
234.
The district nodal officer.
No, my lord, only for the register. Register.
That is 2 and 3.
23.
Dismissed.
2, 3. 2, 3. 2 and 3 lords.
Call the next one, please.
630. 630.
Dismissed.
631.
Dismissed.
632.
Dismissed.
633.
Lord, I pay for respondent number lordship. Register lordship.
633.
Only yes.
Which register?
633.
Who? Which respondent?
Respondent 5 lordship.
Respondent number 5.
Respondent number 5, SL.
Registrar of Cooperative Societies.
Lordship, respondent number 3.
34.
My lord, in item number 634, 635, and 636, Advocate Dilip Kumar Samanto is appearing for the petitioner. He is not present today. My lord, kindly list this matter in the monthly list of July.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List in the monthly list of July.
Lord, I beg to appear on behalf of the private respondent.
In all three matters?
Yes, yes.
All right, please give your appearance.
I am appearing on behalf of the Union. All 3 matters.
All three matters. All right. Dismissed. For the petitioner?
And I'm the petitioner. I'm challenging an order by which I have been told to remove the buildings constructed therein by the PWD, although I have a decree in my favor which says that a portion of that such land is mine and not that of PWD, and PWD was a party to that particular suit. I'll just come to the impugned order first. Thereafter, I'll show the other document, my record of rights and the decree, my lord. Page 15 is the impugned order. I file my affidavit.
Page 15.
15 is my, this is
10-1. 10-1 order is appealable under 10-4. Why are you here?
that.
Please come. The petitioner is aggrieved by a notice. No. By an order.
This is a notice. This is not an order, my lord.
You have been found to meet encroachment. You are requested to remove. If you fail, so it's an order. Order passed under section 10 within bracket 2 of the West Bengal Highway Act, 1964. Stop paragraph. The order impugned is an appealable one. Stop. Next. In view of the above, the court is not inclined to exercise jurisdiction in the matter. Stop. The writ petition fails and is hereby dismissed. Stop. It will be open for the petitioner to approach the appellate authority with his grievances for redressal. Anybody there for the authority? Nobody is there. Service is taken on record. Next.
Prosecuting this matter, I am appearing on behalf of the.
I am for the petitioner.
Central Bank of India.
I am for the petitioner. The petitioner is the secretary, assistant secretary, and treasurer of the Mohila Cooperative Society. There is a 2 bank account in the name of the said bank, said Mohila Cooperative Society. No, without having any prior intimation, without having any reason, both of the bank account has been freezed, and for that reason, no financial transaction is being operated for a prolonged period. I have
Which
made
bank?
One is the Punjab National Bank and second one is the Central Bank of India. I have made a representation. My lord, kindly come to my application at page 11. I made a representation to the all concerned authority along with the all bank managers. Till date, no action has been taken.
Who is appearing for the bank?
Lord, I am appearing for the bank.
Which bank?
Central Bank of India.
All right.
Contact number 8.
Yes.
Actually, your lordship, the committee of the society has been changed, and they have intimated the bank, and their names has been incorporated in the bank.
The new ones.
New one.
No, my lord.
I am appearing.
No, my lord.
I
That
am
is the totally
appearing on
wrong
behalf of the
submission.
new
My lord,
committee.
kindly
Lord, the
consider
petitioners-
this letter.
Petitioners are not in the committee below.
No.
Lordship,
Yes,
The
everything
election of the election of
Actually, I
the
have
committee
prepared
will be
opposition,
held on
but why
shortly.
that has been
For that reason, I have been intimated to deposit the essential testimonials and documents to the concerned authority. Kindly peruse the same. And everything will be
Cooperative. These are
clear.
cooperative societies.
Yes, my lord.
Why have you not implemented the Registrar of Cooperative Societies as parties?
That is different issue. My lord, issue is that it is this Mohila Cooperative
Whether
Society.
the cooperative society is running in accordance with law is the main thing.
Yes, it is under the surveillance of the BDO. My lord, it is under
Page
the
number
surveillance
16.
of the BDO.
This is my position. Actually, I am not submitting due to my.
My lord, kindly peruse this letter.
Lord, the new committee is not included as part of
If-
petition, my lord.
because
The
the
present secretary, treasurer, everybody belongs.
No, my lord.
And they are not included as.
Your no will not do. Somebody is saying that you are not in the helm of affairs.
This letter, kindly, my lord.
Yeah, new committee to that.
Well, this letter has been issued on 5th of June
Who is for the
2025.
state? Are you there for the state? Who's for the state?
The Block Development
Union
Officer
of
House
India.
Gram 2 has issued this letter in my favor to deposit the register, membership register, general ledger, etc. to deposit to his office for the purpose of conducting the election. And I have made party. I have made party to the Block Development Officer House Gram 2.
Does it mean that you are still there?
Yes. For that
it
reason,
does not mean.
Isma Tara Begum is the petitioner number 2.
Maybe has been appointed as special officer. The deputy.
I am handing over the new committee.
Begum is the petitioner number 1, who is the secretary of the Mohila Cooperative Society.
This is the new committee.
If the Mohila Cooperative Society is run by the Block
None
Development
appears on
Officer,
behalf.
and I have made party.
None appears on behalf of the state respondents. Stop. The petitioners claim to be members of a cooperative society, of a registered cooperative society. Stop. They allege that the bank is not permitting them to operate their bank accounts. Stop. Learned advocate representing the Central Bank of India relies upon a communication made by
Page number 16, Your Lord.
communication dated 9th July 2024. Made by certain members claiming themselves to be the functionaries of the cooperative society. Stop. The learned advocate representing the present members of the cooperative society submits that the present members have not been impleaded as party respondents in the instant writ petition. Stop. It is the stand of the present members that the petitioners do not have any right to administer the affairs of the cooperative society. Stop paragraph. As the state is not represented, comma, the court is not in a position to ascertain the status of the petitioners in the subject cooperative society. Stop. Let a further notice be served upon the learned advocate representing the state respondents. Release the matter for further consideration in the combined monthly list of July.
And my lord, kindly record Lord, the maintainability of the writ petition, my lord. The Cooperative Act, there is section 102. The
Cooperative
Register of
Societies
Cooperative.
Acts, yes. You are not a party over here.
Because,
you have
because
to be.
this cooperative is being operated by the Block Development Officer, my lord.
Why don't you file an application for being added?
My lord, I will file.
Next day, I am not passing any order.
Position be recorded, Your Lord.
What has happened to your opposition? Who has eaten them up?
Sorry, Your Lordship. And apology, pray apology, Your Lordship.
Affidavit in opposition filed on behalf of the Central Bank of India. In court today, be written with the records, serve copies.
Then, my lord, kindly give me a liberty to file
It will be open for the petitioners to file reply to the opposition filed in court today. ঠিক আছে? Mr. Dolapati, since you are here,
My lord.
in one matter, this court has directed payment of cost of rupees 10,000 to the Bar Association. What do you propose to do with the money?
Lord, we are paying this money to the poor members for as medical assistance.
How can you ascertain who is poor and who is not poor?
Lord, our system is, Lord, the
Do you receive
member will
applications
make an application
to the Bar Association?
to the Bar Association along with all prescriptions and documents of the nursing home or hospitals.
And you all are giving the money?
And in our committee members, my lord, we put it in our executive committee and the executive committee decided.
Please maintain records
My lord.
with regard to the
My lord, grateful, my lord.
amount that are being received.
Secretary himself very poor.
Yes.
Keep affidavit of
And till
Yes,
today,
service is taken on record.
I am proud to say, my lord, 250 members is getting financial assistance from the bar within 1 year.
All right, next matter, please.
Identical order may be passed, item number 622. So, my lord,
622.
my lord, this the rehabilitation scheme, I could not produce that point of time, my lord.
All right.
And the similar order passed by my lord just.
Is it a time-bound scheme? Is it a time-bound scheme?
No, no.
Open-ended?
Going on, my lord.
Scheme is going on. Are you aware of any such scheme?
Not aware, my
Check up.
My lord, this
I have passed order in 622
an order
directing, yes, directing the BDO to consider the case of the petitioner in terms of the scheme.
If at all invoke.
Yes, well, see,
Obviously, if it
that
is not there,
submission
it's
made
not
by
there.
Lordship, kindly take care of that, Lordship. I don't have any.
Hence, this submission has been taken note by my lord Justice Bosak. If the scheme is exist, then the consequences.
Yes.
This is that, my lord.
622, same order as 622. Just add one line. Provided the subject scheme is in vogue till date.
Yes.
ওখানে স্কিম কনসিডার করতে বলা হয়েছে, ঠিক আছে? এই লাইনটা ওখানেও যাবে, এখানেও থাকবে। Yes.
Grateful.
Grateful. Affidavit of service.
Yes.
Madam, for the respondent number 9.
Please enter your appearance. Dismiss for default. Oh, yes.
Lordship,
For the petitioner? Are you there?
Yes, I am for the petitioner.
Sir, Anirban Dottu is appearing for the state due to his father's illness. He could not come to court, Your Lordship. I have been instructed to pay for not to take, Your Lordship.
Yes, let me see what the matter is about. What is the matter?
Matter is, my lord, that in 1954, a plot of land in Kollari Township was allotted to one person. Subsequently, that person, after obtaining permission from the competent authority, that is the respondent number 1 and 2, transferred that plot of land to the predecessors of the private respondents number 4 to 11 in the year 1973. Subsequently, that Shantigopal Bhattacharya.
Who are you representing?
I am representing the
private respondent.
Shantigopal Bhattacharya transferred the land to Amarendra Narayan Dey in 1974. Subsequently, Amarendra Narayan Dey died leaving this.
What you want, please say.
I want the execution of the lease deed, registration and execution of the lease deed and transfer deed in our favor. We are the petitioners. We, along with the private respondents, applied for transfer of the plot of land in favor of the petitioner. That application was granted, and the government authorities, the respondent number 1 and 2, directed us to deposit the transfer permission fees of 3,21,111, and we subsequently deposited it. But
where is that document to show?
That is document is page number 63-4, minor.
Do one thing. An accommodation has been sought for on behalf of the learned advocate representing the state respondents. Stop. Let the matter appear in the combined monthly list of July. Call the next one. Dismissed.
Lordship, I am appearing for the state respondents.
Please enter your appearance. And mind you, do not give names of any learned advocates who are not there. Every day I see your name and there are 2 or 3 names on top. Nobody is appearing in court. Do not give. Give your name, it will be recorded.
Lordship, candid submission, what happens at that time?
No, do not make submission. Only put your name and delete the names of the others who are there in the slip. Next. Dismissed.
I appear for the statement.
Yes, please enter appearance. Dismissed.
My lord, I am for the State Bank of India.
Yes.
Amount of rupees 10 lakhs has been deducted illegally without serving any notice from the bank account of the petitioner. Initially, my lord, the husband of the petitioner has been issued a loan in the month of April 2022, my lord. He started to pay his regular EMIs. In the month of October, he suddenly died. But the account from which the money has been deducted, it belongs to the wife, my lord. It is neither the joint account with the petitioner's husband.
And was the wife a guarantor to the loan?
No, my lord, insofar as I have annexed the, my lord, agreement letter at page 13, my lord.
What is the bank's
Not
submission?
not applicable, my lord.
The personal loan. Personal loan was taken against the salary account of Sarojit Das. It was taken on 22nd of August 2020. No, sorry, my lord, 6th of April 2022. Sarojit Das expired on 2nd of November 2022. Thereafter, this EMI was stopped. Bank declared it was as NPA account. Thereafter, as per the agreement between the parties, bank has every right to recover the amount from his retirement benefit because it was attached with the salary account, my lord. Kindly come to the page, my lord. It was an agreement. The clause, my lord, the heading is personal loan agreement, my lord. It is after.
Why have you not paginated this?
Sir, it's a rules paper, I'm sorry, my lord. May I hand over my copy, my lord? It is marked, my lord.
No, but then the pages should tally.
Pagination was not done, my lord. I'm sorry. But
do one thing. Please come. The petitioner is aggrieved by the act on the part of the bank in deducting certain amount from her personal account for adjustment of the loan granted in favor of her husband since deceased. Stop paragraph. Learned advocate for the bank relies upon certain documents. Stop. The bank is directed to file a report by way of affidavit. Stop. Let such report be prepared and circulated by 11th July. Release the matter on 22nd of July.
Lord, may I get
An
a copy of the
exception,
agreement, my lord?
an exception to the report may be filed by the petitioner prior to the adjourned date. Service is taken on record. এই কাগজগুলো ফেরত দিয়ে দেবেন।
Affidavit of service be kept with the record.
Yes.
Full lord.
6:45. Dismissed. 6:43. Not this week. An adjournment has been sought for on behalf of the learned advocate representing the petitioner. Stop list in the monthly list of July.
I appear for the petitioner, my lord. My lord, this writ petition has been challenged by the Apollo hospitals against a decision made by the West Bengal Clinical Establishment Regulatory Commission, imposing a fine of 50,000 rupees. My lord, which in our most respectful submission is completely perverse and without reasons. My lord, may I indicate in very brief what the facts?
But then let them file an opposition because since it's a final order, it cannot be done without an opposition.
Lordship, my only prayer would be in that case, Lordship, in the order, the allegations made in the complaint of the patient party relates to treatment protocols, which the impugned order has already referred to the West Bengal Medical Council. But only because we wanted to substantiate certain arguments which were made by the complainant, we asked for an opportunity to give a clarification. The very fact that we gave the clarification
on that ground itself, the fine is given. Now, there is a recovery mechanism under the Act. So, my lord, we will not stand in the way of any affidavit, my lord, which may be filed. In the meantime, let them not proceed with the realization of the fine till the matter is decided by the West Bengal Medical.
As of now, no interim order, please come. The order passed by the West Bengal Clinical Establishment Regulatory Commission
My lord.
on
My lord, 22nd May 2023. That is at page 16.
From page 16 to 28, lordship.
22nd May 2023 is impugned in the instant writ petition. Stop. The matter is to be heard upon exchange of affidavits. 6 weeks will be all right? 6 to?
Lord, we are the commission.
Yes.
We have nothing to say because Lord, we have
Right.
passed the order.
All
But
right.
the complaint that is annexed and that their reply that is also annexed. Lord,
Right.
we do not have anything to develop the
All
entire
right.
thing of the case. Because we have received the complaint, thereafter they have filed their reply.
Number 2 is the complainant.
Yes, Lord, that
Where
he
is the
main person.
complainant
No.
represented?
My lord, we have in our affidavit of service, lordship, we have served twice, my lord. It's been refused both by hand and by and by post. It says two intimations. It has returned as unclaimed.
What I can do, my lord, subject to a lordship's sanction, I can intimate through the commission to the complainant. That I can. Because there are phone numbers, my lord, that is there.
কি বললাম ওটা? Exchange of affidavits, ঠিক আছে? The respondent number 2 may file the opposition within a period of 4 weeks, reply if any, within a fortnight thereafter. Stop liberty to mention the matter for hearing immediately on conclusion of the aforesaid time period. The affidavit of service filed in court today implies that the private respondent number 2 could not be served. Stop. Let the private respondent number 2 be communicated about this order through the
Regulatory commission.
Respondent number 1, lord.
Will it be proper? Under which police station does this respondent number 2 stay?
My lord, that lordship I would have to check.
East Rajdanga Main Road.
My lord, here it says, my lord, according to the complaint, post Ruby. Ruby post.
If my lord provides for the jurisdictional police station, lordship, then we'll find out and we'll
Find out and give it. Be served through the jurisdiction, through the officer in charge of the jurisdictional police station. Stop.
Actually, this thing happens, my lord, usually they are residing in a rented house at the time of the Lord,
maybe
litigation. Thereafter,
maybe
they left the
thereafter
place. They left the place.
Cannot be traced.
My lord, in that case,
Maybe.
lordship, if the commission shares the phone numbers with us, my
Yes,
lord,
yes,
at
I
least
can,
that is how we can get in touch. Because
Right?
lordship.
The unserved writ petition is opened from the envelope and handed over to the learned advocate for the petitioner. The envelope is retained with the records. Take back the writ petition.
Lordship.
I'm grateful.
Yes.
Grateful, man.
My lord, I beg to appear for the Reserve Bank of India.
Enter your appearance, please. Dismiss for default.
Much obliged.
But I am appearing for respondent number 3 and 4.
In item 648?
Yes, my lord.
All right, please enter your appearance.
My lord.
649.
Grateful.
Lordship, I am for the Axis Bank, Lordship. Lordship, may I be permitted, Lordship? Lordship, in this matter, we got the information that the account account was defreezed, and we have also informed to the petitioner regarding this, and this is the communication from the
Is
bank.
the petitioner operating the account?
Yes, petitioner is operating.
Now it is operating.
Yes.
Dismiss for default. Learned advocate for the bank submits upon instruction that the bank account of the petitioner has been defreezed and the petitioner is currently operating the bank account. The communicating letter of the bank.
Axis Bank. Respondent number 3 and 4.
Yes, be written with the records. Lettered date টাও একটু বসিয়ে দেবেন. Is written with the records. All right. Dismissed. This is the last matter.
Lordship, kindly mention 600 and 601. You kindly restore the matter.
Who was your other side?
Other side, I inform the other side.
Please inform. 601 restored.